go ahead and officially open this meeting. Just a quick reminder, if you're not speaking, please mute your mics, because otherwise we're going to get a lot of back feed here from the microphones. With that, Ms. Taylor, if you please call the roll.
Good morning, Chairman
Good morning.
Vasquez,
I guess the whole team.
Vice Chair Schaefer,
Here.
Member Gaines,
Here.
Member Cohen,
Present.
Deputy Controller Stowers.
Here.
So we have a full group here. Everybody's in attendance. With that, let me start off with our Pledge of Allegiance, if I can get you all to stand, and we'll begin with the Pledge of Allegiance. Ready to begin. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Members, just once again, real quickly, let me just remind us all that we are all on a shared line. And today I understand we have some added participants and guests that'll be on the same line with us. So for those especially new that have joined us today for their presentations, just a quick reminder that to be patient with us, and because we're all on the same and sharing the same line, I ask you that you all please identify yourself and be recognized before you speak, so our transcriptionists can clearly hear and properly record this meeting. So with that, let me ask Ms. Taylor if she would please announce our first order of business.
Our first order of business is an announcement regarding public teleconference participation. Good morning, and thank you for joining today's Board of Equalization meeting via teleconference. Throughout the duration of today's meeting, you will primarily be in a listen-only mode. As you may know from our public agenda notice and our website, we have requested that individuals who wish to make a public comment fill out the public comment submission form found on our additional information webpage in advance of today's meeting, or alternatively, participate in today's meeting by providing your public comment live. After the presentation of an item has concluded, we will begin by identifying any public comment requests that have been received by our board proceeding staff, with the AT&T operator providing directions for you to identify yourself. After all known public commenters have been called, the operator will also provide public comment instructions to individuals participating via teleconference. Accordingly, if you intend to make a public comment today, we recommend dialing into the meeting on the teleconference line, as the audio broadcast on our website experiences a 1 to 3 minute delay. When giving a public comment, please limit your remarks to 3 minutes. We ask that everyone who is not intending to make a public comment please mute their line or minimize background noise. If there are technical difficulties when we are in the public comment portion of our meeting, we will do our best to read submitted comments into the record at appropriate time. Thank you for your patience and understanding. Our first order of business will be item M, Public Policy Hearing, 1A, Proposition 19 Implementation, Part 1, Strike Team Reports on the Proposition 19, the Home Protection for Seniors, Severely Disabled, Families, and the Victims of Wildfire or Natural Disasters Act of 2020. This item will be presented by Chairman Vasquez.
Hello.
Thank you. With that, members, let me just, before I begin with my opening remarks, just once again, thank you, especially the staff and the members' staff, for all your support and in working with me this last year as the chair, and looking forward to continuing working with you as I begin my second year as the chair. And just wanted to thank everybody, especially the staff members, because I know I've I'm sure I've put you through a lot of headaches this last year, but we've had some very challenging times given the situation with COVID and everything else that we have on our agenda. So with that, I just wanted to begin the new year, wishing everybody good health, and hopefully we'll get past this COVID here soon now with the vaccination moving forward, because I know many of us are probably having this cabin fever and are just can't wait to reunite with our members, especially our members in person and the public. But today we are ready to begin, I believe, a very exciting and interesting, but it looks like, as I'm looking at this Proposition 19, and I know many of you have looked at the information and have read the staff reports and all the documents that we received, and it's pretty intense. But we'll get started here. On this hearing today, we're really looking to listen and discuss these reports and concerns, these deadlines, these legislative proposals, and the next steps needed for the successful implementation of Prop 19 in about 30 days. I heard from assessors that this is the biggest change in our property tax system since Prop 13, which was back in 1978. It changed 5 parts of the state constitution, and as we will hear today, it will require revisions to 4 to 5 different statutes and several property tax rules, as well as the production of 7 to 10 new or revised forms, letters to the assessors, LTAs. Most important, this law impacts thousands of people, almost 70,000 people annually, who would transfer their property to a child or grandchild, and more than 10,000 annually who want to transfer the base year value of their home to a replacement home elsewhere in the state. Today's hearing provides an opportunity for everyone to ask questions, voice concerns, and provide input. This is critical to the board, assessors, and the legislature to help us to craft the best possible legislation, rules, guidance, and forms in a short time we have. For this reason, we will be in listening and question and answer mode today, and will record and document all input. This gives us time to consider all we've heard and learned overnight, and return tomorrow with a well-informed action item and motions we need to take so that we can enter a proposal into the legislative process next week. For anyone listening or wanting to participate today, we will take up tomorrow item M1B, board member discussion and action on strike team reports, sub items 1, 2, 3, and 4 on page 3 of the agenda. Members, I would like to give give now the opportunity for any members to make any opening remarks if they choose to before we begin. Hearing and seeing none, I will go ahead. We will now proceed with Part 1A, the strike team reports on the Proposition 19. During this part of today's hearing, we have 5 reports on 5 different aspects of the implementation of Prop 19 delivered by the speakers who are listed on page 2 of our agenda. After the board members have finished their questions and discussions with the speakers, we will open the lines for public comments. Please try to keep your input and concerns focused on the topic as shown on the agenda to the extent possible. Thank you. Ms. Taylor, if you would please first call the first sub item.
Thank you. The first sub item is M1A1, the legal analysis of current law and applicable guidance presented by Mr. Moon. Mr. Moon?
Hi, this is Richard Moon. Good morning, Chairman Vasquez and members of the board. I'm with the legal department, and I'm here to present the legal memorandum that's attached to the public agenda notice that discusses Prop 19. As you know, Prop 19 was approved on November 3rd by the voters, and for property tax assessment purposes, there were two main parts dealing with two different property tax provisions. One was the base year value transfer provisions, and one was the parent-child, grandparent-grandchild exclusions. There are a number of questions that Prop 19 leaves unanswered or ambiguous, but that need to be answered so that it can be properly implemented and administered. And because BOE has the authority and responsibility to prescribe rules and regulations to govern assessors when assessing, and also to prepare and issue instructions to promote uniformity when assessing property, BOE is required to analyze and interpret Prop 19 and issue guidance to assessors so that its provisions can be uniformly and most effectively administered. The legal memo before you, as well as really all of the strike teams and this meeting in general, is in fulfillment of those requirements. I won't go through all of the details of the specific changes Prop 19 made, since you already have that information from past meetings. But the matrix that's been produced, and again is part of this, the agenda notice, and that everyone is now familiar with, highlighted a number of questions raised by the County Assessed Properties Division and also the California Assessors Association that need to be answered. And this memo answers what was perceived to be the most pressing of those questions, again, so that the proposition can be properly implemented and administered. In answering those questions, the general interpretational principle we're required to follow is to effectuate the intent of the legislature. And the best evidence of that intent is the actual words of the provision. For Prop 19, the legislature's intent is expressly stated, and for the base year value transfer provisions, that intent was to limit property tax increases on primary residences by removing unfair location restrictions on certain types of homeowners. And for the parent-child and grandparent-grandchild exclusion provisions, the intent was to limit property tax increases on family homes used as a primary residence by protecting the right of parents and grandparents to pass on their family home to their children and grandchildren for continued use as a primary residence, while eliminating what the express language calls unfair tax loopholes used by some. Where necessary, we also looked at legislative analyses, ballot arguments, and other extrinsic documents. Turning to the specific questions addressed, they're broken into two groups, mirroring the two exclusions dealt with by Prop 19. Again, the base year value transfer provisions and the parent-child, grandparent-grandchild exclusion provisions. For the base year value transfer provisions, there were 4 questions and answers regarding timing and qualification. And the most important question, perhaps, of these was the question of whether both the sale and purchase of a primary residence needed to be after April 1, 2021, which is the operative date. The answer that we came up with based on the explicit text is that it's the transfer that's important, and that transfer needs to be done after April 1, 2021. And this means that as long as either the sale of the primary residence or the purchase of the replacement primary residence is done after that date, it will qualify. And of course, that's assuming that all of the other requirements are also met. For the parent-child exclusion and the grandparent-grandchild exclusions, the memo addresses 7 different questions. And one important question was whether the family home needed to continue as the family home of all of the children. The text of Prop 19 does not answer that question explicitly, but we believe as long as one child maintains the home as the family home, that requirement is satisfied. We also believe that if the family home is no longer maintained as the family home, the exclusion will be lost, but also that any child who initially received a portion of the family home can make it his or her family home and not lose the exclusion. So just as an example, if a parent were to pass and give the family home to her 3 children, There's a question of whether it's enough to have only one of the children maintain the property as the family home, or whether all three must use the home as the family home. Again, the text of Prop 19 is unclear, but we believe that as long as one of the three make it their family home, that the transfer will qualify for the new exclusion. After living in the family home, again, as an example, for 5 years, if that initial child who made the home the family home moves out and decides to rent the property to a third party, the exclusion would then be lost. But if instead another one of the three children decided to move in and make it their family home after the first child moved out, the exclusion could be maintained. We recognize that there are still many questions that need to be answered, and CAPD and legal are working to answer those questions, and we'll publish further guidance at a later date. And we anticipate that the answering of questions and questions such as these will come up and will be an ongoing process, and guidance covering various topics will be issued from time to time. And I'm happy to take any questions that you may have.
Vice Chair Schaefer, I have a question.
Yes. Thank you, Mr. Moon. That was great. And let me start with Vice Chair Schaefer.
Mr. Moon, have you seen the letter from the California Farm Bureau Federation to many of us raising a couple of questions? It's a 3-page letter that I was just presented with this morning.
Yeah, I believe I have seen that letter, and the question that they have, or at least the main question, or what I perceive to be the main question in that letter, is addressed in the legal memo. So their question was regarding family farms and whether there needed to be a principal residence or a family home on that family farm in order for the farm to qualify. And based on the language in the proposition, the legal memorandum concludes that it is not necessary to have a principal residence on the family farm.
Good. Thank you. I have one other question. How do we police the activity of these three children moving in, moving out, etc.? I mean, do we have a deputy member of our staff who oversees babysitting of what happens with one of these claimed exemptions, or do we rely on them to self-report to us, or neighbors tattle on them? Just how do we know what's going on?
Yeah, that's a great question, because that's one of the many details that's not expressly addressed in the proposition. And so that will be a consideration in the draft legislation. And I believe there's a provision in the draft legislation that allows the assessor to ask for information and requires a child who makes the home the family home, if it's no longer the family home, to report that to the assessor. And of course, as the proposition is administered and as assessors learn how things are going and what would or would not be helpful to administering the proposition, that could be added to regulations or legislation.
Well, I might like to see the assessor required to annually or every 3 years, some period of time, make an inquiry to assess, just to determine just what the facts are. Okay?
Yes.
Thank you.
This is Member Gaines. Could I ask?
Member Gaines, yes, go ahead. I know you had some questions as well.
Yeah, I just want to thank Mr. Moon for the clarity on the family farm issue, that it is a parcel that could be passed on, because we have so many family farms here, and the interpretation from the very beginning by the farming community, the Farm Bureau, and others was that these parcels could be passed down the family. The other clarification is that there's a limit on this of $1 million, but that would apply per parcel because you have many farms where they acquire different parcels over maybe even decades of time. And so that's a very important aspect, that $1 million limit would be applied per parcel. So yeah, thank you for your presentation. Appreciate it.
Chairman Vasquez, this is Deputy Controller Stowers.
Yeah, Ms. Stowers, go ahead.
Yes, kind of going on with the family farm, I do appreciate the analysis and the entire legal analysis. And you're saying that you don't have to have it your primary resident for the family farm to qualify. So that legal advice is in direct conflict with that LTA that we issued late last year. So I would like to know what are the plans to correct that LTA or send out an additional LTA on that issue?
So I know that there is in the works, I guess for lack of a better way to describe it, an LTA that puts together a lot of the questions and answers that we've been getting and that we've been trying to answer, and that will certainly be addressed. In terms of correcting what's already out there, perhaps Dave Young could address that.
Yes, good morning all. This is David Young, Deputy Director of the Property Tax Department. Mr. Moon is absolutely right. We are looking through our guidance, not only our recently issued guidance, but also our prior guidance from many years ago, and we are reviewing those and seeing where all these inconsistencies and where revisions and corrections will be needed. And we are planning on issuing LTAs or other guidance to reflect what is currently out there. So he is correct.
And a follow-up question, Deputy Controller Stowers here. When we say transfer of a family farm, the family farm has to be actually owned by the parent or the grandchild or the grandparents. Could it be held in a corporation?
Because it's the transfer of real property that's being excluded, it could not be held in a corporation.
We've had that issue in the past, so I'm assuming that our advice would clearly state that.
Yes, that can be one of the questions in that question and answer LTA.
Thank you.
Thank you. Member Cohen, do you have any questions or comments? Okay. I have just a couple quick ones before we move on. Mr. Moon, you mentioned the fact that I guess February 15th is a holiday. So is it correct to assume that if somebody was to file a parent-to-child claim on the next day, I guess it would be the 16th, it would still fall under the current law? Is that correct?
Yeah. So it's actually the purchase or the transfer that would need to happen by the text of the proposition on the 15th. So the triggering action or event is not the filing of the form, but the transfer. And so if the transfer happens before that date, then they would be fine. I guess I shouldn't say fine, but they would be under the old rules.
Okay. And then my second question is, you also said that, on this whole transfer fee, for example, if this transfer fee is denied, the exclusion, can they file a claim for a refund with the Board of Supervisors? And if the board denies that, can they go to court? Or are they able to appeal this thing to the AAB as another option, I guess?
So if the parent-child exclusion claim is denied because the homeowner's exemption or the disabled veterans exemption is denied, they would not have recourse to the Assessment Appeals Board, and their recourse would be to file a claim for refund. And then when that's denied, then they would need to file an action in Superior Court.
Okay. And then my third question is, in the educational field, California Educational Code has a definition of severely disabled as individuals with exceptional needs that include serious emotional disturbances or severe intellectual disabilities. I am not sure what the definition possibly be useful in interpreting this Prop 19 definition.
Yeah, so we looked at several different definitions, and the one we started with was the one that's most closest to property tax, and that's there is a definition referred to in Section 69.5, which is the current base year value transfer for 55 and over individuals. And so we took a look at that definition, but the big difference, and this gets a little bit technical, but the big difference between Prop 19 and what's in Section 69.5 vis-a-vis the severely disabled requirement is that for 69.5 purposes, they changed the definition of severely disabled to severely and permanently disabled. And essentially what that means is that the disablement has to be a physical one. And so because the word permanently disabled was not used in Proposition 19, that led us to believe that the definition of severely disabled would be more broad than the definition of severely and permanently disabled. And so the definition in Proposition 19 of severely disabled would not include the requirement that it be a physical disablement. So in that regard, I believe it would be consistent with the educational code definition, but there is a definition of severely and permanently disabled. I believe it's in Section 74.3. And I believe, if I'm not mistaken, the draft legislation reflects a tweaked version of that definition.
Thank you. And then just one last quick question. You gave a scenario where, I guess, in the event a parent passes away and wills this over to, I guess, 3 siblings, and, as long as one of them identifies it as their principal residency, they qualify for this exemption. I'm wondering what happens when, let's say there's only one, and that sibling happens to pass away, 2 or 3 years later. Is he or she able to will that to her kids and still qualify for this exemption?
Yes, that person who passes away could take advantage of the exclusion, but of course, his or her children would be subject to the same requirements, meaning that his children would then be required to use that home as a family home as well.
Okay, thank you. Thanks. Oh, I see Member Cohen. Yes, go ahead.
Thank you very much for recognizing me. Good morning, ladies and gentlemen. My question to the speaker, and my apologies if you already addressed this in your presentation, I just missed it. What happens if a property is in an irrevocable trust? How does law apply to that situation?
I'm assuming that you would mean with regard to the parent-child exclusion.
Yes, that is correct.
Yeah, and if the property is in an irrevocable trust, the property is transferred at the time the property goes into that trust. And so all of the rules that are now in Prop 19 would apply at that time, at the time of that transfer.
What happens if the property was transferred years ago in an irrevocable trust, well before Prop 19 was ever thought of, let alone voted on? Does that mean it's still? Yeah, please go ahead.
If it was put into an irrevocable trust, it's considered to have transferred on the date that it was put into the trust. So if that was a long time ago, whatever the rules were at that time would be applied then. And then as long as it stays in that irrevocable trust, that ownership won't change.
Thank you. Thank you.
Thank you. Members, if there's no other further questions from the members, let me ask Ms. Taylor if there's any public comments written, or if there's somebody on the line that wishes to speak on Mr. Moon's report.
Yes, thank you, Chair. We do have written comments, which I will read, and then we'll move to the AT&T line to open it up for public comment. Our first comment is from Sandra. Under Prop 58, currently a claim for exclusion from reassessment for a parent-to-child transfer will be timely if filed within 6 months after the date of mailing of a notice of supplemental or escape assessment for the property, even if it was not filed with 3 years of the change of ownership. My understanding is that taxpayers will still have 3 years to file the exclusion for a transfer that occurred before Prop 19 is implemented, such as a death prior to 2/16/21, in order to obtain retroactive exclusion from reassessment. Otherwise, it will only be prospective relief. Will the rule regarding timely filing also continue to allow the timely filing of a Prop 58 claim within 60 days of the notice of supplemental or escape assessment in order to obtain retroactive relief, even if that 60-day period would take us beyond 2/16/21? Our next comment is from Jeff. I am a real estate agent and would like to know how to advise my elderly client on her closing timelines. Does everything need to occur April 1st, 21 or later? Can we press now with closing her sale in Orange County in preparation for closing on her new property in San Luis Obispo County? Our next comment is from Sharon. How does it affect children who will live in the house as a primary residence? And our last written comment is from Carol. I would like to understand family farm better. According to the legal analysis, a family farm does not have to have a primary residence for it to be passed on within the current statute or when Prop 19 is implemented without a tax increase. We have a newly acquired adjacent parcel, 5 acres, that has always been leased for agricultural farming, which we do now. It sits directly in front of us with a right-of-way between the parcels as a road, but there are 2 district parcels, one with the primary residence and the other cultivated. Would both be able to be passed on without changing the taxes? And I misspoke. We have one more comment from Allison. Proposition 19 was presented saying that family farms were exempt. Now that it has passed, we see there is no exemption. They are treated the same as a primary residence with the parent-child limited exclusion. This was a complete misrepresentation. When looking for guidance from the Farm Bureau and the California Cattlemen's Association, we were told they also thought the family farm was exempt. Now, trying to navigate these new rules, I've spoken with my estate planning attorney, assessor's office, and BOE, and nobody can answer my questions, concerns. It appears the rules are being decided after the fact. This is unfair. Also, to have such a short time limit with the rules not even decided, how can anyone make an educated decision on how to proceed? This will have such a dramatic effect on family ranches and farms. Most will be taxed out of agriculture even after generations of succession planning. I ask that you truly do exempt family farms as the proposition was originally presented. The only ones making out on this proposition is the real estate industry that wrote it. I feel very wronged by the system.
Ms.
AT&T
Taylor.
moderator?
Yes, please check with AT&T.
AT&T moderator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter at this time?
Sure, thank you. If you'd like to state public comment, you may press *1 at this time. star 1 for any public comment. Star 1 for any public comment at this time. And there are no public comments at this time.
Thank you. Member Gaines, did you have another question before I thought I saw you make a motion, or at least move to ask a question?
I did. I just wanted to follow up on Member Cohen's question. She asked the question in reference to a home being passed on in a trust. And so I just like some clarification. She mentioned irrevocable trust. How about a revocable trust or a living trust?
So for Mr. Gaines, this is Richard Moon from the Legal Department. So for a revocable trust or a living trust, it would depend on when the property that's placed in that revocable trust goes, I guess the simplest way to put it is it goes to somebody irrevocably. So when it's passed to somebody, and typically that would happen on the death of the person making the living trust or the revocable trust. And so the property would be considered to be transferred at that time.
I see. Okay. Okay, at the time that the trust is written?
The time that the trust becomes irrevocable.
Okay. All right. So there would have to be a irrevocable clause within a living trust. Is that correct? Or just an irrevocable trust itself?
Yeah, no, typically the way that the revocable trusts will work, or the living trust will work, is that, for example, a parent may put a house puts a house in a living trust for the benefit of their child. When the parent passes away, the trust will become irrevocable, and then the house will be considered to have been transferred to the child at that point.
Okay. Whereas with an irrevocable trust, that's set up front. And so if that
Correct.
was done. Yeah. Okay.
Yeah, at the date the property is transferred into the trust.
Okay. And then just to clarify again, when we're dealing with a rental, let's say a parent had a home, and then they had let's say they kept their first home and they bought a second home, moved into it, and the first home became a rental situation like that. There is no protection or exemption for the rental home. Is that correct?
That is correct.
And so if that were to pass on to family members, it would be reappraised upon the death of the second parent.
Correct.
Okay. Very well. Thank you.
Thank you. Any other questions? Oh, it looks like Member Cohen has some.
Yes, thank you, Mr. Chair. Mr. Moon, I appreciate your expertise on studying up and learning this piece of legislation. I want to make sure I heard you correctly what you were telling Member Gaines. Only one piece of property can be transferred from parent to child. Is that correct?
Well, only the principal residence or the family home can be transferred.
Okay, so that means that if the parents own multiple pieces of property, they're excluded in being transferred.
Correct. So if they own multiple properties, only the property that is their family home can be transferred to the child under this exclusion.
Okay. Now, how does the law determine what's the family home versus the rental property?
Well, the family home is,
so let me explain. So here's parents have 4 kids, and they have 4 pieces of property, and they want to transfer each property to each kid. How does the assessor, how do they determine which home is the family home with that?
Well, the family home is defined within Prop 19 as the principal residence, and so of the 4 properties the parents owned, the one that they could pass under the exclusion is the one that they use as their principal residence.
And I guess tax documentations will support that, right? I don't know how you. I would imagine that's how it would be done.
I apologize. You broke up there, so I couldn't hear what you.
Oh, okay. So that's okay. I think I've got my answer. My question was, how do you determine which is the family home unless the family discloses it?
Yeah, that would be one of the things that would need to be on the form, some type of certification or assertion that it actually is the family home.
And what kind of certification or assertion qualifies as acceptable?
Well, I think that's part of what needs to be in the legislation. Currently, there needs to be a certification essentially stating that it's the principal residence.
Yes, so it sounds like the certification is ambiguous. We don't really know what it is. That's the follow-up legislation that needs to happen.
Yeah, well, we know that it absolutely needs to be the principal residence, and as to how the assessor actually verifies that, that's not stated explicitly.
Okay, thank you. That clears it up. And this is for any property, whether they're in a trust, an irrevocable trust or a revocable trust. This rule.
Correct. Yeah, the form of holding the property is not. It's not going to have an effect on these rules. I mean, depending on how you hold it, it might be when these rules operate, but the actual operation of the rules is not affected by the form of the way it's held.
All right, thank you. Mr. Chair, I have no other questions. Mr. Moon, you're incredibly insightful and knowledgeable, and I'm grateful for your time and expertise.
Thank you.
Chair
Maskler?
Yes, Member Stowers, go ahead.
Thank you. I think I've asked this question before, but I'm going to ask it again. When it comes to the public comments that we are receiving, I know that we are going to issue guidance, LTAs that are going to respond to a lot of these questions, but I am curious if we're going to reach out to the constituents directly and provide them a one-on-one response to the extent that we can. I know we are, but I just want to put it out there for the record.
Good point. And actually, along those lines, I was going to ask Mr. Moon, especially after we heard the public or the written testimony, if he had any thoughts on some of those questions that they raised.
Well, first, in terms of responding to the individual commenters, I believe it is part of our practice to have one of our departments. I think typically it's the taxpayer rights advocate who responds individually after talking with the property tax department and if necessary with legal as well. With regard to the specific comments that were made during this public comment period, I guess we haven't had a chance to look at any of the comments in detail, but just from what I heard being read, I think a couple of those comments or parts of those comments are answered in the legal memo. Particularly, there was a question with regard to filing, and although the filing requirements are not spelled out in Prop 19, I think sort of the assumption we're working under, and I think what's reflected in the draft legislation at this point, is that the filing requirements would be the same or very similar as to what's required currently under the current parent-child exclusion and grandparent-grandchild exclusion.
Thank you.
Chair Vasquez?
Yes, Member
Can I
Gaines,
follow
go ahead.
up with Mr. Moon with one final question?
Sure.
Because this comes up too. I want to make sure that our constituents have clarity, but basically what we've talked about with other property owned that is not a home there is not an exemption for. So I'm thinking specifically if you had a cabin, under the old scenario, that cabin could be passed on to children and grandchildren. That is not the case anymore with Prop 19. I want to make sure I'm accurate in that statement.
Yeah, that is correct. If that cabin is not the principal residence of the parents, it will not qualify for Prop 19.
Yes. Okay. Very well. Thank you.
And Vice Chair Schaefer here.
Vice Chair Schaefer, go ahead.
I was advised by staff that we have several anonymous opinions to be presented to us, and I just want to point out that if somebody is anonymous, they have no reasonable expectation of a response. So we are absolved of having to worry about that.
That is true. But listening to the comments and the discussion right now, especially on this primary residence, I have a quick question for Mr. Moon, and let me just put it out there. So let's say a parent owns 4 properties and wants to will each one to 4 siblings or their children, right? And you mentioned the only one that's going to qualify for the exemption is the primary residence, which I'm assuming would be the one that they're currently living in or they were living in, not the income property, for example, right?
Correct.
And so what happens to the other 3 properties that are willed to their kids? They get it, but they're going to get hit with the tax, right?
Correct. At the date of the transfer to the 3 children, the properties would be reassessed at that point.
And under the current law, they wouldn't be, right?
They wouldn't be up to $1 million.
Under the current law?
Under the current law.
Okay. And under this new law, there's no $1 million, it's everything, right? On the additional properties.
Correct. Yes,
okay.
That's correct.
Thank you. With that, unless I don't see any other comments,
we have some public comments on the phone.
I'm sorry?
We have additional public comments on the phone.
Oh, yes, go ahead.
Okay, and it's 10 for your public comments. One moment while we gather their name. For public comment will come from Roberta.
I have property that my son lives in it as his principal residence. So that is his home, of which he owns 50% and I own 50%. So on my passing, does his principal residence, of which I own 50%, then get reassessed? That's my question.
Chair Vasquez, that's a pretty straightforward question, and if you'd like me to, I can address that.
Sure, go ahead.
So in that situation, the 50% that you own that would pass to your child who is living in the home currently as a family home, and it sounds like you're living there as well.
No,
it would
I am
be
not
reassessed.
living there.
Yeah, it would not be reassessed.
I'm sorry, could you repeat that again? I am not living in the home. The son is living it as his principal resident, but I am 50% co-owner.
Yeah, it would need to be your residence in order for it to qualify.
But it is not.
Then it will not qualify.
So then his principal residence, of which I own 50% and I am not co-owner, then gets reassessed.
Not his 50%, your 50%.
Correct. Thank you.
Yeah.
Was there any
Thank
other
you.
public? comment, or was that
Yes,
it?
one moment while we get, nope, we have a few in there. We're getting their names. One moment, please.
No problem.
And just as a reminder, it is 10 if you'd like public comment. One moment, sorry for the delay. One moment. And our next question will come from Audrey. Please state your first name and your last name.
Audrey Fagioni.
Your line is open. Please go ahead.
Okay. Is there any consideration at this time of the possibility of a Biden tax plan that's going to tax capital gains at time of transfer, as well as lowering the estate tax exclusion? How this affects families that are inheriting that, as well as, or that are inheriting property, and as well as having the property taxes raised at the same time? How, just the unfairness of it all?
Chairman Vasquez, this is Richard Moon. If I could make a suggestion, perhaps it would be a better tack to take all of the comments and questions that are on the line now, and then have staff reply to them so that they can give it the attention that each of the questions needs.
I was going to suggest that. That's a good idea. Let's do that. Is there anybody else on the public line?
Thank you. And our next question will come from Peter. Please state your last name.
Hi, Peter Kaiser.
Your line is open.
Okay. I've been reading this, the proposition, and it talks about eliminating unfair tax loopholes, and it talks about East Coast. Peter Kaiser, and the proposition actually talks about eliminating unfair tax loopholes used by East Coast investors, celebrities, wealthy non-California residents, etc. And this doesn't apply to many hardworking middle-class families who were saving up and buying additional vacation homes and so forth. And this may even prevent most of those from being used by their children if the tax rate goes from a few $100s, the annual property tax, to maybe $8,000–10,000 a year for that child. And so this may mean that this will have to be sold because they can't afford to do that. And if we look carefully at who sponsored this bill, apparently the Real Estate Association, I think it spent over $50 million to put this through. And this would mean, of course, that if these children all have to, most of them have to sell their homes, the second homes, then there would be a very much expanded amount of business for these realtors. And I was wondering if was this one of the purposes of this proposition, and it's going to really hamper these children from using their normal vacation homes and so forth, which have been kept up, and a lot of money has been spent on these over the years. So I'm just wondering, and if these are put into trusts, whether living or irrevocable trusts, can you still retain the previous assessed value of these second homes that are not primary residences? And thank you very much for this hearing. It's a very confusing time, and the time rate is maybe less than a month away. So can those trusts be modified to handle these issues to protect these hardworking middle-class families?
Thank you for your comments. We will have staff get back to you. Is there any other public comment?
Yes, our next comment will come from Robert Siegel. Please go ahead. Your line is open.
Thank you, ma'am. Good morning, members. Robert Spiegel on behalf of the California Farm Bureau Federation. I wanted to start this morning with to thanks and appreciate the opportunity to address the board and board staff on Prop 19 implementation. This is a matter of which is of crucial importance to the members of my organization and California's agricultural community. First and foremost, though, I would like to thank legal counsel for agreeing with our interpretation relative to question 6 on page 10 of the legal memorandum, that being which, quote, must a family farm also be the principal residence of the transferee, end quote. For the reasons correctly identified by Mr. Moon and his team, the answer is unequivocally no. The trigger in this instance is not whether the family farm be the principal residence, but rather does the family farm continue in the manner for growing agricultural commodities, grazing livestock, or other agricultural related endeavors. Of all of the numerous clarifying and operational questions that folks have related to Prop 19 implementation, we believe this to be one of the most critical in ensuring that the transfers of the family farm were eligible for transfer without necessarily triggering a complete full market value reassessment or valuation. The plain fact is that our farms and our land holdings are quite different than simply a second home, a vacation property, or any other commercial property, and those are no longer afforded the same exclusion under Prop 19. So the importance of this interpretation cannot be understated and is appreciated by my organization. The second matter I'll address is related to the multiple parcels in the value test referenced in section 2.1C1A and B of the initiative, and this was brought up by Member Gaines. As we know, any transfers occurring on or before February 15th this year will be eligible for the Prop 58 and Prop 193 transfer exclusions. However, beginning on February 16th, the exclusion is narrowed to that of a family home as a principal residence or a family farm. Prop 19's value test effectively eliminated the exclusion of what used to be the first $1 million of all other real property transferred. And essentially, this was a cumulative lifetime limit for the intergenerational transfer. So Prop 19's value test applies to all real property being transferred. As such, it's imperative that each individual parcel to determine whether or not that parcel exceeds the sum of the factored base year value plus $1 million. It's possible that under the value test, the transfer of some property may not trigger a factored base year value adjustment, meaning that the child could assume the base year value of the parent and thus not assume any additional tax burden. These issues were more fully addressed in our January 7th letter to the board and staff. So I'd like to end my comments by recognizing those and the suggestions and clarifying points made by the California Assessors Association. The assistance that the individual county assessors have provided to the members of my organization related to Prop 19 implementation has been valuable, and I wanted to express our appreciation as well. Farm Bureau continues to receive numerous inquiries as to how Prop 19 will be implemented and what impacts the initiative may have on California's farming and ranching families. It's urgent that the Board of Equalization further clarify and address the issues raised in our letter, and do again appreciate the legal clarification mentioned at the start of my comments this morning. We at Farm Bureau intend to stay engaged with all the stakeholders as this process continues, and thank you for your consideration and opportunity to comment today. Thank you.
Thank you. Any other comments?
Yes, our next one will come from Janice Carey. Your line is open.
Yes, thank you for allowing me to talk to you today. My name is Janice Carey, and I'm contacting you as just a homeowner that is a senior who is dealing with the fact that my husband works 100 miles away in Salinas, but we live in the Santa Clara County area, And because of the property tax that would be engaged, even though we could afford a house down there, we couldn't move. So I thank you very much. For us, it becomes a really great matter that we can use this. However, there's a bit of confusion. Even my real estate agent doesn't quite understand when we can make this work. Even though it says April 19th and I heard April 21st batted around, we're looking at houses, but we have to tell people we can't close until after April 21st. We're also not sure when we can sell our house so the whole thing goes through so that we can afford getting in with Prop 19. So we really would appreciate, many of us, and finding out what exactly is what we can do so that we can stay legally within the parameters of Prop 19.
Thank you.
Thank you. And the next question will come from Marianne Welsh. Your line is open.
Yes, my question is basically, is it not reasonable to assume that 600 to 700% tax increase is excessive due to the fact that this was an underhanded Proposition 19? It offends both the civil rights issue, unconstitutional prejudice, plus it has two separate issues, which is against Article 28, Section 4, 2.1b. You only are supposed to have one basic subject on any proposition. This has more than one, and it has two separate, and they twisted it, and they tried to put it as far as, oh, well, it's just talking about taxes. Not true. It is underhanded. The legislators did not do their work right. They tried to change Proposition 58, which was basically an inheritance. And in my personal opinion, inheritance is a right. And right now, the state of California is taking that right away from all of us. But the tax situation, any property you have that you do not live in, the taxes will go up anywhere from 600 to 700%. Do you people not think this is excessive taxation without real representation? Because the legislators work for the legislators. They do not work for the people of California. That's my statement. Thank you.
Thank you.
Thank you. Our
Anybody
next question
else?
will come from Richard Watts.
Yes, hi, good morning. I appreciate you taking the call. You might have already covered this subject, but I wasn't able to hear it. I heard about irrevocable trusts and the status of transfer, and that there would be reassessment upon transfer. Was there any engagement about the issue of this specific trust called a qualified personal residence trust, which is something that's utilized quite often here? In my case, I'm a senior. This is something that gifts your residence to your children over a period of sometimes 30 years. And of course, that was done for us 20 years ago, 25 years ago. And if now this were to reassess midstream of that trust, that would put us in a taxation place, which would be very difficult in a retirement mode. And I just wondered if QPERTs or qualified personal residence trusts were going to, how those were going to be considered with regard to reassessment.
Thank you.
Thank you. And our next question will come from Judy Grable. Judy?
Good morning. Yes, thank you for taking my call. It's Trudy Grable, and I work in Santa Clara County, where our housing prices are incredibly inflated. And, you know, I've lived here for 40 years. I have a child with special needs. I also work with families who have children with special needs. And I'm wondering how 65.9 versus Prop 19 affects them. You know, when we leave our homes to our children, it reduces the burden of caring and providing housing for our sons and daughters. And with that kind of taxation, living on SSI, there's no way our individuals are going to be able to meet the HCBS requirement of being a full and contributing member of their own community. And so I am really concerned about what's going to happen to my child when I die, who lives on $900 a month, and I have made provisions for her to receive this home in a special needs irrevocable trust. However, she won't get that until I die. And my only option at this point is to transfer the home to her now, which then takes the home out of my, ownership. And that too is not an option. So I am really concerned about what's going to happen to our disabled population who rely on public benefits and are going to be expected to pay taxes on a home that's been owned by the home for 30 years. And now the property value has, gone up so high that there is no way that they'd be able to pay taxes on the current value of their home. And thank you for taking my concerns, and I hope that an exception will be considered for individuals who receive public benefits.
Thank you. That's a good point.
And our next question will come from Marianne Nicholas.
Yes, Trudy just actually, thank goodness, stole my thunder because she said it so much better than I did. I have a daughter with special needs, and I have the same thing. She's under the disabled dependent child, and we've put put our house into this trust as well. And I guess the comment I would say, first of all, thank you so much for having us being able to comment. But a lot of these things have been brought up about revocable, irrevocable, even when it comes to the farmland. It seems as though that should have been prior knowledge before voting, and it seems right now that actually a lot of this is just getting a little bit more solidified even with the Board of Equalization. So it's difficult to vote on something that you're not really privy to, and actually it really seems to be a lot more fluid and it's getting a little bit more solid, but not really in our favor. So anyhow, thank you. I appreciate what you're doing. Thank you so much.
Thank you.
Thank you. Our next question will come from Alexander Sher. Please go ahead.
Thank you. I have a question clarifying the issue of the transfer in a circumstance where there's a decedent with a trust that becomes irrevocable on death. The date of death is in 2019, so it predates the proposition. But in the case of an investment property, not residential property, the actual transfer is being held up and won't occur until after February of this year. The trust did become irrevocable upon death of the decedent. There are multiple siblings, so there's not a transfer to a specific beneficiary yet. We think we know to which beneficiary that investment home is going to be transferred. And so my question is, since the date of death and therefore the irrevocability of the trust came into effect prior to the effective date of the proposition, but the actual transfer to an as yet indeterminate beneficiary is after February 2020, and it's investment property, will the transfer be backdated to the date of death in that circumstance? That's my question.
Thank you.
And our next question will come from John Bentoncourt. Please go ahead. Your line's open.
Yeah, we're cattle ranchers right on the edge of the East Bay, and we're in a Williamson Act contract at the time, and we solely want to keep this ranch in production as a cattle ranch for my son. At the time of reassessment, will that take place on the resale value or on the value under the Williamson Act of the agricultural value of the land?
Thank you.
Our next question will come from Lorna Chris. Your line is open.
Yes, I'd like to know if we were to place the property, our home, into an irrevocable trust, should we do so before the February 15th deadline? And if so, what are the tax implications if we do this before February 15th? This home is currently occupied by me and my daughter, and I intend to leave the home to my daughter. Then a further question is, if we do, within this irrevocable trust, place the home as being transferred to my daughter before February 15th, is she then, she has no children, is she then able to transfer it upon her death to either a niece or nephew to keep it in the family? And if so, does it stay under the exclusion?
Thank you.
And our next question will come from Esther Cat.
Yes, this is Esther. Thank you for taking my call. Actually, my question is exactly the same as the previous caller. I don't know what, she didn't specify a name. I guess I missed the name. But yes, if we place our property into an irrevocable trust before the 15th, what are the implications? Will it be able to transfer upon death to my kids' beneficiaries without being reassessed?
Thank you.
And our last question, and for public comment, will come from Vanessa Chavez. Please go ahead.
Good morning, members. Vanessa Chavez with the California Association of Realtors. With respect to the first round of proposed Prop 19 follow-up legislation, CAR has two immediate concerns, one of which requires swift action by the legislature to provide clarity for California homeowners across the state. First, and of most immediate concern, is how the April 1st effective date impacts property transfers needs to be clarified in legislation. Specifically, legislation is needed to clarify that the purchase or sale of either the original or replacement property may occur prior to April 1st, 2021. CAR legal analysis of this issue and the intent of the initiative concurs with the opinion of the BOE Chief Counsel as put in the question 1 of their memorandum, Prop 19 initial interpretation questions and answers dated January 8th, 2021, which states as subdivision B of section 2.1 that the operative requirement is that the transfer of the base year value must be on or after April 1st and not the purchase or sale of either the original or replacement property. This is the most pressing issue for us, as express legislation would allow California homeowners to feel secure in their decision making prior to the effective date. Regarding the issue of calculating a new tax basis, CAR believes that Prop 19's calculation of a new tax base must be consistent with the provisions included in existing law as outlined in Revenue and Taxation Code 69.5, which implement Prop 6B, which remain in the Constitution. As you are aware, Section 2.1 D2A and B of Proposition 19 address the calculation of the tax base. Section A expressly utilizes the term of equal or lesser value, yet the proposed legislation does not address A or the term. Revenue and Taxation Code 69.5 G5 defines equal or lesser value for the Prop 60 constitutional provision, which includes the formula for calculating the tax base for when a property is sold. CAR believes that the provisions for calculating the tax base should remain consistent with what is currently in existing law, since the term appears twice within the same constitutional article, Article 13A, on the identical subject matter. Therefore, it should have the same meaning. CAR would like to thank the BOE and its staff for their engagement on the issue. We look forward to continuing to work with the BOE, the California Professional Firefighters, the California Assessors Association, and other stakeholders to provide timely clarification to the provisions of Prop 19. Thank you so much.
Thank you. Ms. Taylor, I'm assuming that was the last one?
Yes, that's my understanding.
We do have someone else queued up. From the line of Tricia Crane, your line is open.
Good morning. Good morning. Tricia Crane. I'm a Santa Monica resident. Greetings to Mr. Vasquez. And I am the chair of a neighborhood association that met just last week many, many people, a much larger meeting than we ever have had, because people are really confused and taken by surprise. The reason being that the full text of Prop 19 was not included in the ballot, and people had no idea that the knock-on effects were going to be as dramatic as they are. They had no idea that their inheritance was endangered by this proposition that will only benefit the realtors. There are huge implications, as you've heard, from families that are not wealthy, specifically families with children who are disabled and who have been counting on being able to gift their home to their children. These are adults who cannot afford the increased property taxes that have been foisted on us as the market has pushed up the value of our family homes. And now people are going to face having to sell them and lose the security they once were able to offer to their children. So I really thank you for your work on this. I think that this is very, very problematic for the security of our working class and middle class who have only had their family homes to leave to their children and are now threatened with losing them. I would really ask you to look at the implications for the security of a huge population in California and the very misleading nature of this proposition. Thank you.
Thank you. And our next question or comment comes from Olga Cuba. Your line is open.
Hi, I would like to thank you, first of all, for having this meeting and giving us the opportunity to listen for Prop 19. My concern was being from a big family of 7. My parents, who live in Santa Monica, have worked very hard, my dad being a gardener all his life. They got a little bit of money, bought 2 properties in Santa Monica, and we're planning to give these triplex and a fourplex to their 7 children. But now that this proposition has been passed, my parents are very concerned that their dream and hard work will not go to their children. They wanted to have a stable place for their children to live with, and since not all their children went to school, some have some type of disabilities and will need a home to live in. Now, living in Santa Monica is very expensive. And if the properties would have to be reevaluated, what would that mean to their children, to their hard work? That would mean that the children would have to sell the properties and would have to move from California, a place where Santa Monica, where they were raised. It's very concerning because my parents did not have the opportunity to take us to trips. We didn't go to restaurants. We didn't have all that when we were raised because my parents were trying to make a capital to be able to give to their children to be able to live in a 1-bedroom apartment in Santa Monica. So it's a concern to us that this Proposition 19 didn't really think about the whole situations of middle-class people or lower-middle-class people. So I just wanted to let you know how some people are feeling about this proposition and how can it be changed so it doesn't really affect the middle-class people that work so hard. Thank you so much for listening. I just needed to let you guys know how my family, how my parents are feeling about this. Thank you.
And our next question or comment comes from the line of Lorna. Chris, your line is open.
Yes, I'm wondering, are the decisions that we make under Prop 19 as it stands now irrevocable? That goes to the bigger issue that there seem to be there are undoubtedly, or we would hope, going to be revisions made in this proposition as the proposition was both poorly worded and confusing to so many. So what we want to know is if we make a decision, which we seem to be forced to do before February 15th, and there is a revision to Prop 19 put on the ballot at some point in the future, are the decisions that we make prior to February 15th irrevocable, or is there going to be some step back that we could take and go to revisit this whole thing?
And at this time, we have no further questions in queue.
Mr. Chair, this is Malia Cohen. May I speak? Can you guys hear me okay? Okay, I'm just going to go ahead. I'm not sure which one he is, but I want to thank every member of the public that came out to speak to this issue. It's incredibly important, and I can certainly feel the pain and the frustration and the disappointment. It almost feels like government kind of let us down, particularly for those people who, like my family, my parents worked very, very hard to own their property and now is faced with this immediate transfer of ownership. A couple thoughts. First, I want to pose to the great thinkers on this call, the staff, how do we reverse this legislation or address where the gaps and the loopholes are? I think it's an important question to ask on the record, and this is for the benefit of those persons that are calling in. That's my first question. And then my second question, or more or less as a statement, occurred to me that we probably need to be doing more outreach between now and the deadline in February 16th. And I will be partnering with my county assessors to start to do some online town halls on this legislation and the impacts that it will have. For those of you that don't know, my name is Malia Cohen. I represent District 2, which is 1/4 of the state of California. Every county, 22 counties from Santa Barbara all the way north to Del Norte County. A lot of coastal communities. I myself reside in San Francisco. My parents live in San Francisco. Most of my family is in the immediate Bay Area. So it's a very expensive market. So I'm incredibly sensitive to folks that live in expensive parts of the country. Also represent the Monterey area, and so there's a lot of farmland also in my constituency. So I'm going to partner with my assessors to try to bring information, a PowerPoint presentation, and just educate people very, very quickly. So my original question was posed to staff. Can someone tell me, how do we correct a lot of the gaps in this legislation that was passed by initiative? It was placed on the ballot. So I don't know if it's Mr. Moon that takes the question, but it's out there. Thank you. I appreciate it if someone can answer.
Ms. Cohen, this is Richard Moon from the legal department. Because this was passed as a voter ballot initiative by the voters, it would require another ballot initiative to undo this. As you said, there are some gaps or unanswered questions, and to the extent that those exist, that could be those gaps could be filled or questions answered through legislation.
Mr. Moon, are you part of the effort to work with the legislature to address these challenges that we've heard on the line today?
Yes, currently the California Assessors Association is working on draft legislation, and staff members, including myself, are working in partnership with them.
Thank you. And do you know how we could get a status update as to what's happening with your efforts?
Yeah, I believe that will be the next part of the strike team report.
All right, I appreciate that. So to the members of the public, please stay tuned for some answers or options to remedy some of these challenges that we've heard. Thank you. I have no further comment.
This is Member Gaines. I'm wondering if I could just follow up on Member Cohen's comments, just briefly.
Sure, go ahead. Members,
Great.
I just lost my internet connection, so I'm on the phone.
Oh, okay. All right.
Just so you know. Anyway, go ahead, Member Gaines.
Yeah, I wanted to thank Member Cohen for her comments about outreach, because I think this is a moment when we need to do more outreach in terms of Prop 19 and providing clarity for our constituents. And so I think in the weeks ahead, we ought to be focusing on our districts and reaching out and answering questions with regard to the lack of clarity in parts of the initiative. I'm sure we'll be gleaning a lot more information through the course of today and tomorrow on where those areas are, and working together collaboratively with our assessors, but also with our own leadership within the BOE, making sure that we're communicating with the legislature and seeing if we can figure out some of these gray areas that don't have the clarity that our constituents need. So, thank you.
Thank you. Ms. Taylor, I got cut off there, so I was wondering, we're pretty much done with public comment, right?
Correct.
So did you, when I lost the connection here, did you read off the next sub-item or not yet?
Not yet.
Okay. Do you want to go ahead and begin the next sub-item?
Yes. The next sub-item is M1A3, the proposed draft legislation presented by Mr. Ernest Dronenberg, Mr. Jeff Prang, Mr. Richard Moon, and Mr. David Young.
Hello, do we have everybody here?
Hi, this is Ernie Dronenberg. Can you hear me?
I can hear you.
Okay. Many of the questions that were just answered have already been answered and are ready to be drafted. I need to thank Jesse Salinas, the past chair of our legislative committee at the CAA, and Don Gakel, because both of those persons immediately in November established a ad hoc committee was made up of assessors, assessor staff, Board of Equalization, legal staff, and regular staff. And they've been working for over 2 months now on the corrections. And we believe that there's a collaborative decision on all the pieces that have been talked about earlier today, with, of course, the current law, which answers some of the questions that were already answered. This effort was really, I can't say how much it was. People, we had 70 people on the call at times, and they were working through the holidays and Saturdays and Sundays to get to a product that we then took to the legislators' committee consultants for taxation. Now, the process and the details of the process, I'm going to let the chairman, our current chairman, because it passed from Jesse to the assessor of LA County, Jeff, and Jeff's going to explain the process, and he's got his technical staff ready to behind him for any technical questions. But we have a bill, and he'll explain it, that's already drafted. It's ready to go, and it was over, the initial draft was over 35 pages. So, Jeff, why don't you take over from here?
Thank you, Assessor Dronenberg. Mr. Chair, members of the board, thank you for the opportunity to address you and let you know some of the work that we've been engaged in over the course of the last couple of months since the election. I did want to let you know that I have a hard stop at 11:45, so I will, at that point, if we're not done, I will just let my staff continue from that that point forward. As Mr. Dronenberg said, I'm serving as the legislative chair of the California Assessors Association this year. I'm happy to have this opportunity to present what has been a collaborative legislative development effort between the California Assessors Association as well as the Board of Equalization staff. And I do want to emphasize what the Assessor Dronenberg stated, that we've worked very, very closely with board staff over the course of the last month or two to respond to the needs in Proposition 19. I'm looking forward to working with each one of you as well as the board staff to find, clarify and correct deficiencies in order that we can more effectively enact the will of the voters. Prop 19 may have brought confusion to our world as administrators and government officials, but I think we can all agree that this is about finding a quick and expedient way to administer the duly enacted laws of the people of California, while at the same time we need to ensure fair and equitable treatment for all. But if you'll indulge me for just a brief second, I did want to highlight and personally thank some of the staff people who have been working pretty tirelessly and literally weekends and through the holidays to get where we are today. From the board, Brenda Fleming and David Young, Richard Moon, and Glenda Schultz have been valuable. From my staff, Nicole White Gamble, Brian Donnelly, Crystal Taylor, Lisa Lucero, Robert Large, and Aaron Fanwick. From San Luis Obispo, Barbara Edgington. From Santa Clara, David Ginsborg and Nora Galvez. And from San Bernardino, Teresa Valdez. And I also want to acknowledge San Luis Obispo Assessor Tom Bordonaro, who quarterbacked the California Assessors Association Prop 19 Ad Hoc Committee, which did a lot of the heavy lifting to prepare us for this legislative package. I really could go on, but this has been obviously a statewide effort. We received input from many other stakeholders, engaged in a pretty robust and healthy discussions between all the assessors in California. There are many others from the BOE, but and from the various county assessors who took leading role and help put in countless hours to put together this comprehensive legislative Prop 19 package, which I believe you've all seen. With that being said, I want to focus on how we got here and what our collaborative efforts have accomplished. So I did as an aside, in preparation for the November election, I think a lot of us were much more concerned about the administrative challenges of Prop 15, which consumed most of our time. But now that we're focused on Prop 19, we're discovering that it is also quite a challenge. And candidly, I'm not sure what we would have done if both of these measures had passed, because we're simply outgunned and overwhelmed. As it became apparent that Prop 19 was going to be certified, the Board of Equalization, in conjunction with the Assessors Association, accelerated the discussions about what we're going to need to implement the measure. Formally, as I indicated, we created an ad hoc committee at the association led by Assessor Bordonaro. Board of Equalization staff helped to identify a number of the issues regarding the implementation challenges. And from this effort and from your support and direction, the BOE devised the strike teams to focus on individual aspects of implementing the proposition. In particular, the strike team that I'm most familiar with is the team designated to draft legislative text necessary to implement Prop 19. In that regard, I want to take you through the legislative package and highlight some of the key elements that, if passed by the legislature, will help all of us provide clear guidance to the public. And once again, we really appreciate the support and guidance we receive from board staff. The starting point of our legislative package really began with guidance from the ad hoc committee, the legislative committee, the executive committee of the CAA, and board staff. Interpreting what Prop 19 does and does not do was, frankly, a Herculean feat in and of itself. As a constitutional amendment, we had to know what could be clarified by the legislature, what's in the Constitution, what sort of things could be done by the board and amongst assessors as in terms of standardization of policy. Additionally, we had to know what laws Prop 19 changed and or repealed. There is some discussion and difference as to what that what those points are, and that will have to be decided by the legislature. Once we did have, however, a fundamental understanding of what the legislative intent, we could begin writing the legislative text that we hope will pass this year in the legislature. Before I get too involved in the highlights of that text, I did want to mention that Nicole White Gamble, who's the Director of Operations for my office, and Barbara Edgington from the San Luis Obispo County, they were the primary authors and technicians in developing the CAA legislative package. They're both on the line, and they're available to answer more technical questions that you may have about the proposed legislations, and I may defer a number of questions to them. So let me first touch on a couple of key provisions of our proposed legislation. First and foremost, the legislative package attempts to offer clear and more precise language to provide for emergency rulemaking authority by your board in many areas. And I think it's a consensus among anyone who has delved into the details of Prop 19 that assessors absolutely cannot implement Prop 19 without the Board of Equalization taking a lead and providing guidance in how we can uniformly administer the various provisions of the measure until such time that a legislative package is adopted. I will say, as an aside, that Prop 19 was rushed onto the ballot. There were innumerable deficiencies, and it puts both the board as well as assessors in a very awkward position. We are not policymakers. We implement the law as adopted. The adopted law creates a tremendous amount of lack of clarity. Somebody has to make a policy decision as to how that should be interpreted. That typically is not county assessors. It's more likely the Board of Equalization, but even you, I suspect, are going to find constraints based on what type of authority you have to make changes. But since we can't get the legislation passed until later in the legislative session, we have to do something in order to implement it in this interim period, and we're going to have to improvise. So dealing with the first topic, emergency rulemaking, specifically, we need the Board of Equalization to take the lead on one, statewide tracking requirements of data, the movement of taxpayers from one property to another, since qualified Prop 19 applicants can move their base year as many as 3 times. Also, the creation of the required forms. We're engaged in public education. We need the Board of Equalization to work with us to ensure uniform public education throughout the state. We're going to need letters to assessors that include complex value calculation and the needed comparison tests. All these things are absolutely critical for us to even begin administering Prop 19. Additionally, the proposed legislative text clarifies conditions that must be met in order to receive the benefit for parent to child and grandparent to grandchild exclusions. As has been stated by Mr. Moon, the property must be the primary residence of the parent or grandparent if they're the ones transferring the property. This benefit goes both ways, but in most cases, the child or the grandchild is the one receiving the property. The property must become the primary residence of the child or grandchild within 1 year, within filing of the homeowner's exemption. And Member Cohen, we did one of those tools that we will be looking at to determine whether it's the primary residence or not would be the homeowner's exemption application. Only the primary residence qualifies for a base year transfer. Other property no longer qualifies for that benefit. And separation of farm family from the residence, so that no residency is necessarily required for a family farm, also requires more detailed clarification. The challenge is the provisions of this component of Prop 19 is supposed to begin on February 16th. We are not ready. I don't know that we will be ready on February 16th, so I am anticipating significant and potentially overwhelming public service challenges for my department, as well as other, I'm sure the assessors will have the same thing. Additional provisions I want to highlight are legislative clarifications that will provide for clarification. For instance, if the original home is sold before April 1st and the replacement property is purchased after April 1st, which rules apply? Current rules are Prop 19. The definition of severely disabled needs clarification if Prop 19 extends to both cognitive and or mental disability, or is it just physical disability? clarification on whether each spouse is able to claim the base year transfer independently or if they're viewed as a single entity. As you all know all too well, I'm certain that attempting to get legislation passed is difficult in the best of times and requires a lot of patience, persistence, and understanding. I did want to, at this point, acknowledge that Rob Grosklauer, who is the legislative advocate for the California Assessors Association, he's on the line. He will be available to answer specific questions about a lot of our legislative negotiations to date. Policy hearings typically don't take place until March for many of the legislative committees in the first year of the new session. Our work in collaboration with other stakeholders gives us the opportunity to, that we hope that will to pass our legislative proposal in a committee bill, which typically allows us to bypass some of the hurdles of passing an authored bill. Whether we're able to pass this legislative proposal in a committee bill or if we need to find authors, I think I can state pretty definitively that this is an area where you as board members can really help us push this effort forward to provide education and briefings to lawmakers to stress the urgency and the clarification that's needed for this measure to be administered. And it's important to emphasize that we are the administrators attempting to provide clear guidance to constituents on a proposition that the legislature authored and left up to the voters to put into law. I can envision that the deficiencies in Prop 19 will generate incalculable public service challenges for assessors. Property owners are eager to make decisions now about estate planning at a time when we simply do not have the clarity on all the provisions of law and where mistakes are extremely likely to be made. The Board of Equalization Assessors, we didn't draft the law, but we are the ones who are assigned to administer it and to respond to the public need. Ultimately, we are going to be held accountable, and we need to convey to the legislature and stress the urgency to get this right and to do it quickly. And I want to go back to what I said previously about passing legislation during challenging times. Due to COVID, the challenges are considerably more extensive and more uncertain. The legislative calendar is in flux, and other external factors are adding complications into the fold. Our reality here is that it is unlikely that we will get this legislative package passed and signed into law by February 16th, which is the first implementation date. As a contingency, in collaboration with BOE staff and other stakeholders, we have undertaken a two-pronged legislative approach. The first one, as I stated earlier, is to get the entire legislative proposal either in a committee bill or through sponsored legislation. The second one is an absolute must-have bill for the parent-to-child provisions that go into effect on February 16th. We have an understanding with the legislative leadership that this must-have proposal may be inserted into a budget committee bill that Governor Newsom is likely to sign by the end of the month. But in consulting with the legislative staff, they've been very clear that the entire legislative proposal does not work in the budget trailer bill process, and that we're going to have to truncate some of our needs and separate the main body of legislation from some of these critical must-have clarifications that hopefully we can insert into this abbreviated process. We're pursuing both approaches, and Rob could give you more details if you want to hear more. But this is probably the one area where your leadership is crucially needed in really helping to inform lawmakers of the urgency of this matter and stressing how we cannot implement the will of the voters without this clarification, and that without clarification, taxpayers, property owners who all have urgent needs are likely to be caught up in red tape and bureaucratic confusion. It may cost them a lot of money and time and create distress in their families. I know the process is slow, but we need to move fast. So with that, I want to introduce or make available Nicole White-Gamble, who can provide a briefing on the specifics of the legislative proposal. And I apologize, but I can't answer any questions right now. I have a hard stop 3 minutes ago. So I'm going to turn this over to my staff to do the best to answer questions from this point forward, and I'm happy to speak with any of you offline later in the day if you have questions for me. Thank you all very much.
Thank you. And
Thank
sorry,
you,
I know
Jeff.
we were delayed a little. Go ahead.
Thanks to Jeff, did a great job. I want to suggest that Rob is available, and the next category is collaborating with the legislature, and he can give us that strategy. But so don't ask questions of these people about anything other than technical aspects, and hold your questions on process till Rob gets up.
Thank you.
Once they present this, you can ask.
Good afternoon. Can you hear me?
Yes, go ahead.
Good afternoon. This is Nicole White Gamble. I'm Director of Rural Services for Assessor Jeffrey Prang. And I just wanted to go ahead and give some additional information regarding the language that we have created and are putting forth in front of the legislature. And I also want to note that Barbie Edgington is also on the line. And so I'm going to ask that she also jump in. As I've been listening to the comments and the inquiries that have come through, I'm hoping that I'll give some insights in terms of what our process has been, how we've moved to get to this point, what our aims and goals are. So essentially, I'm looking at the language. What you'll find is what is attached to the agenda is you actually see the draft language that we have created. And we basically, as a committee and as a group, tackled this in two parts. One part that was dealing with the intergenerational transfers, and by that I mean parent to child, grandparent to grandchild, and also the reverse of that. So that became very important because when we look at the way Prop 19 was written, specifically when we're talking about the intergenerational transfers, we know that one, it has a very aggressive effective date of February 16, 2021. So as administrators who were going to have to implement this language, we wanted to make sure we could get the clearest understanding. And so we've been very appreciative of the collaboration that has happened throughout the state with all of our partners, and of course, the guidance that we've received from the Board of Equalization. The primary documents that have basically informed our decisions are obviously the provisions itself, but we've also looked at and relied heavily on the interpretation or the BOE's legal analysis to help to guide us through this process. So in tackling this, again, like I said, we looked at the first portion of it, which is the intergenerational portion of it. And I think as been noted on the call of significance, of course, it dramatically narrows the benefits that are available now for parents and children to transfer their property. The second way we looked at this and the way we grouped it is we look at this in terms of the base year transfer portion of it. And there's actually two portions to that. One portion specifically deals with disasters. The other is dealing with both the seniors and also the severely disabled. This was important for us to look at this in two ways because when we look at the proposition, we know that it allows for the ability to transfer a base year value from one home, your principal residence, to another throughout the state, which is primarily one of the key pieces of this legislation. But there are differences between the two types. Most notably, there's a 3-time limit for senior and those who are severely disabled. But we do not believe this limit applies to victims of wildfires and disasters. So if someone had to endure this significant loss more than 3 times, there is still relief that they can prevail themselves to. So understanding the order of, or I should say the differences of these types of provisions and the implementation dates, the process we used is we tried to look at this measure and break it up into pieces that would make the most sense. And we also looked at existing language, was very informative and helpful for us in terms of formulating the sections or the new provisions. If you're looking at our document, what you'll see is the CA ad hoc team created 3 new components, and the numbers I'll reference are actually proposed numbers. They don't actually exist. but this is a way for us to tie them back to the existing legislation when appropriate. The first provision or section is 63.2. This deals with all of the intergenerational transfers. The second component is what we refer to as 69.1. This deals with disaster. And then lastly, we have what we call 69.6. This is giving us more details in terms of the seniors and also this disabled exclusions. I want to preface this by saying that obviously, as we're going through this process for all of us, this has been a continuous learning process for us as we try to expand our understanding of what the intent of the legislation is, and then also understanding where those areas are there where there was gray. And when that existed, as much as possible, and standing and appreciating the intent, we try to fill those areas in as much as possible. As Jeff had said, we fully realize and understand our obligation to provide as much clarity and understanding as possible to implement and administer this law. So what I'd like to do is I would like to actually start to reference the document that was provided. And Barbara, what we can do is what I'd like is to start to discuss some of the specifics that were mentioned. I'm going to start off, and if you look at the first page of the document as the attachment, you'll see that in 63.2, there were several questions that were raised. And one of the fundamental questions was the question regarding how farms, family farms, would be handled in the legislation. And it was noted by Richard Moon, I believe, that we are looking at this as saying that the family farm does not have to have a principal residence associated with it. And so when you look at the document, as we go through it, you'll find that the way that we address this is we have several different definitions, including the definition of an agricultural commodity. And another question that was raised that I want to bring up is that there was a question regarding how we'd be looking at these different portions of the family farm. And we define it as an appraisal unit is the unit that we'll be looking at. And as you go through the draft language, you'll see that we actually request that a lot of information is provided to us regarding defining all of the parcels that are associated with the appraisal unit. And then, of course, we would do an analysis to see what types of structures or other things may be associated with it. So this is something where we've clearly delineated the fact that the family farm does not have to have the principal residence associated with it. And we believe that that benefits are two separate benefits. There are also questions regarding what type of information would be required for claimants. And so, as it's been alluded to previously in this call, we would have to have a claim that is submitted to us to give us all of the information so the assessor's office are able to determine the eligibility of the claimant. Other significant portions regarding whether or not, I should say if there's multiple transferees, the question is whether or not all of those transferees would have to live in the property, which is not the case. Obviously, if we had one eligible transferee and they resided in the property, they would be able to claim the exclusion. There were also questions that were raised about how would an assessor determine if a property is the principal residence of a claimant. And essentially, typically, when we talk about the person who's getting the property, we refer to them as the transferor. And the standard usually is they have to be eligible for the homeowner's exemption or the disabled debt. The language of the proposition, Prop 19, is very clear in the fact that the transferee actually has to claim and be approved for the homeowner's exemption within 1 year of moving in. But what we're saying is the standard for the transferor, the person who would be getting the property, is they have to be eligible for that. Some of the ways that we typically would know that someone is their primary residence might be just a few examples, and there are certainly more, and I'm sure we'll get more clarification out there. But typically this may be placed where you actually get your voter's registration, that's the address associated with it, and your driver's license may show this. But also another part of this is the fact that there would be an affidavit that would have to be signed that basically states that for the transferor, it was their principal residence, and then also for the transferee, the person receiving the property, that they were actually occupying and residing in the property. Some of the other questions that were raised were, how would we police? And I don't believe anyone wants to police, but how would we know if the person who is residing in the property is continuing to reside in the property, and what types of assurances would the assessor's office utilize to make sure this was a fact? So in the language, we do have specific documents that do require that the homeowner or the transferee who's in the property is required to notify the assessor if they move out of the property. In addition to that, the draft language, the comprehensive draft language that was submitted, does also allude to the fact that there might be some type of annual requirement for them to affirm that they are still residing in the property.
Nicole, I need to interrupt you for a second because our lobbyist is overbooked, and I want to get him on before he leaves, and then we'll come back to you. Excuse me for the interruption, but we've slid way behind schedule. So, Rob, why don't you tell them what the process is and where we are in the process? I think Board Member Cohen asked about that for sure.
Sure, Ernie, happy to do so. And good afternoon now, everyone. Rob Grosscloser with the California Assessors Association. The CAA, along with the board and many interested parties, have been educating legislative staff in both the Senate and the Assembly, as well as the governor's office, on the clarifications necessary and the sensitivity to the timing of things. That process has been underway for a few weeks now. Due to the legislative calendar limitations and the processes in place in the COVID environment, the ability to pass a full Prop 19 clarification package has yet to be realized. It doesn't mean that it won't occur. It just means that the timing is quite difficult. And so with that, we also might be put into place that a smaller portion of the cleanup will be necessary to meet the February 15th deadline, and then the larger package to be worked on between now and April 1. I think that what Ernie, you've said, and what Assessor Prang has also stated is that it is key for everyone to engage the legislators and that they can be educated and understand both the clarifications necessary and the timing of things. So the legislative process is a very dynamic one, and so I can never be held to a certain timeline, but I can say with assurance that legislative staff are diligently looking at this and working with their various committees and leadership offices to see if there isn't something that could be done to help implement the voters' will and the passage of Prop 19 by the appropriate timelines.
Mr. Jornberg, is there others?
So this is Nicole. I guess Nicole White Gamble. I will just continue very briefly. There were just a couple more points about the document that I wanted to make, and then I think we can move from there. Just to note, there was discussion about the severely disabled, which is under our section 69.6. And I did want to note, just to reiterate, which is what has already been discussed, we do have a definition that is, at least in the draft language, that is a little bit more expansive because it does move beyond both physical disabilities. And the other piece of it was there were several questions and comments made about the ability for there to be prospective relief. This was in regards to the 3 years or also 6 months after receiving notice that someone would still have the ability to file a claim. And I would just like to state that in the language that we provided, The draft language does include sections that address those issues. And then the other thing I wanted to address is the fact that there were lots of questions, and I know that our office, and I'm sure other assessors' office throughout the state, have received the question whether or not do both activities, if they're doing a base year transfer, does both the sale of the original property or the purchase of the replacement property have to occur after April 1st? And based on the legal analysis provided by the BOE and also our understanding of it, I do want to note that the draft language, at least, does state that our interpretation in the language, if it were accepted, does allow for either one of those events to occur after or on April 1st, with the new provisions under Prop 19 being applied. And so the key to that is that then the equal or lesser provision is not in effect. The purchase price of the replacement property could exceed the original, but then of course, based on the ACA language and calculations, the difference would be added on to the current assessed value if that base were transferred. Barbara, I'm going to ask you if there's any other significant points that you think that need to be highlighted at this point. I will make one other point. When you're looking at this document, it looks like it is, and it is a rather large document, but I do want to state that when you're looking at this, there's actually two versions of the document. We like to think of this as a living document, and as we get more information and further understanding, of course, then we've been trying to make updates to it. And so what you'll see is the first portion of the document has a revision date of 1/08/2021, and I want to make note of that. And then what you'll see is, I believe it's after page 17, if I'm not mistaken. Actually, yes, I believe it's page 17. What you'll see is there's also, let's actually go past that. It's actually page 24, still going, I'm sorry. Actually, after page 26, what you'll find is there's a repeat of some of the language. And the difference between those is that as we've learned and we've had more discussions with the legislature, we found that the sunset language that we have for provisions in 69.3, we believe that now our understanding is that that language will not sunset when it comes to the principal residence of the home, that they will run in parallel. And so the latest version from page 1 to page 26 actually is showing the new provisions without that language being included. So I did want to note that in terms of the document. Barbara, I'm going to ask now if there's any other points or key points that you think that need to be highlighted that I may have missed. Would you please share those?
Thank you. This is Barbara Edgington. I'm with the San Luis Obispo County Assessor's Office. I'm a manager in that office. And I think that there's just, Nicole, I thought you did a very nice job, and I appreciate all the work that you've put into it. And thank you, members of the board, for letting us speak on this. I think I only have a couple of things that I'd like to maybe highlight for you, and that is number one, what Nicole just brought up, which is that there will be concurrent versions of how the base year value transfers are to be administered, and there is going to be some confusion about how to basically make the different concurrent versions work together, and so that people would understand which version they would come under. So we will need a lot of assistance in that regard, and a lot of guidance from the Board of Equalization and their staff in helping us to administer that. The second point that I think is going to be important for us to emphasize for you when you're going through this draft is, I heard earlier that regarding a family farm, that the hope was that the exclusion, the $1 million calculation would apply per parcel. And I think that when that was voiced, if the way that I understood that was that the expectation was that it would be per assessor parcel number as opposed to per the family farm unit. The way that our draft reads is that that $1 million exclusion would be handled per the farm unit as opposed to per assessor parcel number. As was mentioned, some of the farms may be a single assessment number and others may have many multiples of assessment numbers. So depending on how the particular county has mapped those particular farm, what's ended up as the farm unit, some farms may end up with many multiples of that $1 million application if it was per assessor parcel number, while others may end up with only $1 million exclusion applied to it. So I think that it's important to, number one, recognize that particular issue, and then to provide guidance to the on how you think that should be administered and by assessment staff, and how you believe consistency can be handled in regard to that. And other than that, I don't think I have anything that I wanted to highlight. And if you have any questions, we'd be happy to try to answer them.
Member Vasquez?
Oh, yes. Member Gaines, go ahead.
Could I just comment in reference to that? Because the whole issue on the, as it relates to farm parcels, was an exemption designed to allow those parcels to pass on to the next generation. And so I just want to reiterate that the understanding, or what's been explained to us, is that would it would break down on a per parcel basis. And but the original intent was an exemption for family farms. So I want to make sure that any interpretation of that is done in a manner that allows the passage of those parcels to the next generation.
Thank you. Is our chair, Mr. Dronenberg, still on the line? Ms. Taylor, did we lose Mr. Dronenberg?
Hi, Tony, I'm sorry. I had the mute button.
Oh.
I would just like to sum up by saying it's so extremely important that we work on this thing with all due diligence. We've gone a long ways, but we have a collaborative method that's been one of the first that I've experienced in my mixed history with the board and the assessors, and it's really been a gratifying process to see working together like this. The next step is to actually introduce the one-page bill, that's the shortened bill, and the full bill into the legislative committees. And it's the one-page bill is what we're hoping to get into the budget trailer bill. You know, I don't know why they call it a budget trailer bill at this point in the legislative process, other than they're going to have a special budget bill this year. And so it would be a budget trailer bill as a part of the special budget the governor hopes to get out by the end of this month. And we've been working with the Speaker's office as well as the committee consultants. They've seen the total package, and they are very complimentary on it, and believe that in total it's a great package. But they just say that we can only move one small piece into this vehicle of the budget trailer bill. We have to take the total package and put it into a regular, hopefully a committee bill. And then once we've got the single page done, then we can take those pieces out of the, I'll call it omnibus bill that includes everything, and then get that one passed. But we need to get it into the process just to get it out by April. But I think that's the summation of our presentation today.
Mrs. Jordan, I had listed, were you also going to have Mr. Moon and Mr. Young weigh in, or is that separate?
No, they're welcome to weigh in, absolutely.
Chairman Vasquez and members, this is Brenda Fleming. Thank you to Assessor Ernie Jornenberg and President of CAA, and also Assessor Prang. What we'd like to do is, and just to acknowledge and give thanks and appreciation to all of the public commenters and to the electeds who have joined us today to participate in this conversation. We thank you for your patience as we've been a bit fluid in moving through today's agenda. What we would like to do, with your permission, members, is to continue the conversation on the agenda items, specifically going through the legislation. That allows us to honor the order of the agenda material and public commenters. And then following that, since we have had the primary speakers on the collaboration with the legislature, I will just, at the end of the presentation on the draft legislation, I can make some comments for you also. What I'd like to do, Chair and members, is to honor the public and others who are on the line, just continue with the order of the business as it's listed on the agenda, if that's your pleasure.
Sure. I have no problem with that. I was just wondering now, since we've heard from Mr. Prang and some of his staff, along with
Right.
Ms. Dronenberg.
We should proceed with the BOE staff and Ms. Richard Moon and Dave Young to make their comments.
Okay, let's do that.
Thank you, sir.
Yes, good afternoon, all. This is David Young, Deputy Director of the Property Tax Department. Thank you for this opportunity to address you all. First of all, I would like to recognize the outstanding efforts and immense amount of work everybody, all the assessors, their staff, and the BOE staff has put into this effort. So my compliments and thank you very much. What I wanted to do here was perhaps move back to the macro level. I know from the discussion from Mr. Moon this morning, from Ms. White-Gamble and Ms. Edgington, that we have really delved into some of the details of Prop 19. If you will just allow me, I would just like to maybe pull back a little and look at it from the macro level. So from the proposed legislation, there are three proposed statutes that were brought up. The first one is 63.2, and 63.2 will implement the parent-child and grandparent-grandchild exclusion. If I could just focus you on some of the key elements that will need to be in there in that legislation. Top of that is, if we are talking about implementation quickly and effectively, top of that is the filing requirements. The whole process starts with the filing requirements. The Prop 19 is a little bit, it does not address it directly, but the proposed legislation 63.2 will give some more specific guidelines on the filing requirements. Also, what 63.2 will address is, as you've already heard, some of the eligibility requirements and the ongoing verification requirements. So those will need to be in there also. And one more element that is key and has been generating a whole lot of discussion on is providing clarification on the family farm. What applies, what is in, what is out, and specifically, the issue has been raised as to what exactly is the unit. Is the unit the individual parcels, or is it the whole farm as a as a whole, as one appraisal unit. So those are some of the elements that will be addressed in 63.2. Moving on to the next one will be 69.1. The proposed section 69.1 will implement the base year value transfer for victims of wildfire and disaster, and very similar to the grandparent-grandchild and the parent-child exclusion. A very needed element in that legislation will be, of course, the filing requirements and very specific filing requirements. Another element in there will be expressed expansion of the base year transfer to all 58 counties, that the counties now you are able to transfer your base year value if your property's been destroyed by a disaster to all 58 counties, and you do not need the county to have a statute that allows you to bring in or import in a base year transfer from another county. And the removal of the value limitations. So now that before you had to qualify under a specific value that had to be equal or the same as the original home, there has been a removal of that requirement. So anything above it, you can transfer it to a replacement home that is actually valued higher, but the difference will be then added to the base year. And then the last proposed legislation will be section 69.6, and that will implement the base year transfer for seniors and the severely disabled. As the same with the other two proposed section, the key element there for implementation is the filing requirements, and that proposed legislation will address that. It will also address the expansion of the benefit, the transfer of up to 3 years, and particularly for the board, it will actually provide that certain information, how many times a person has taken that benefit, be basically reported to the board so the board can track how many times they have transferred a base year value, and when they hit the limit of 3, that they are not eligible for any more. So those are just that is a big macro view of the 3 proposed legislation. I hope that was helpful. I am available for any questions you may have. And if not, I believe Mr. Moon is also available for his comments.
Yes.
Good afternoon. This is Richard Moon with the legal department. Again, and what I'd like to do first is also offer my thanks to CAA and their staff, and in particular, Ms. White Gamble and Ms. Edgington. They were not assigned an easy task, but they really did a fantastic job of pulling things together in a very short time. But it's the nature of legislation that it doesn't address every potential situation. And so what I'd like to address just very briefly is some of the quote-unquote gaps that staff is looking to address, whether that be via guidance in the form of something like an LTA or legal opinions, or rulemaking. And I would also note, as Assessor Prang had mentioned, that the draft legislation explicitly provides authority for the board to do emergency regulation. So that would be available to us should the legislation pass. And so I just wanted to mention several things that we would like to do with future guidance. And one of those things is to explain and to give examples of how the new assessed values would be calculated, whether that's through the parent-child portion of Prop 19 or whether it's the base year value transfers. We'd also like to give examples of how an assessed value would be calculated in the parent-child or grandparent-grandchild situation when the family home is no longer the family home of an eligible transferee. There's language in the draft legislation that describes it, but I think as we all know, legislative language sometimes is not as clear as a concrete specific example. And so that's something that we'd like to do. And we'd also like to give guidance on tracking the effect of Prop 19 as well. Several other things that we would need to, or would look to clarify, is the interaction of the Prop 19 base year value provisions with the existing disaster base year value provisions, more specifically Section 69 and 69.3. We'd also like to give some guidance on the types of property that the base year value transfer could apply to, as well as the types of ownerships that would qualify as well. And by that I mean, for example, what happens if there's a multi-unit property and an over 55 resident lives in one unit of the multi-unit and then wants to transfer the base year value. And so those are some of the specific situations that we would be looking to give guidance on. And then finally, sort of perhaps a more longer-term thinking sort of idea and things to think about would be those changes that may potentially take a constitutional amendment. And there's a couple things here that we've been tossing around, and we will certainly think about further. The first is that the base year value transfer 2-year requirement is in the Constitution itself. But in particular, with respect to disaster relief for base year value transfers after a disaster, 2 years may not be long enough. And so if that 2 years would want to be extended, that would have to be done through a constitutional amendment. And then also if there wanted to be provisions for if something like the pandemic that's occurring now happens, for there to be some type of authority or means to extend that 2 years during that kind of a time. And then the second item that I had wanted to mention was we have gotten a lot of questions about the prospective or retroactive potential relief for transfers that are made, both the purchase and the sale, prior to April 1, 2021. There is currently no prospective or retroactive relief provided for in Prop 19, and if that's something that the legislature deems desirable or necessary to do, that's something that would also need to most likely be done through a constitutional amendment. And those are the things that I had wanted to highlight, and I'm happy to take any questions that you might have.
Mrs. Dronenberg, I believe that concludes all the presenters, correct?
Yes, it does.
Anybody knows?
Let me just remind those that are not speaking to please mute your mic. And just one, thank you, Ms. Dronenberg, and I know Mr. Prang, who had to leave, but then, of course, our staff, Mr. Moon and Mr. Young, for all your dedication, especially over the holidays. I know you guys were working really hard to craft this well thought out legislation. Let me ask the members, you know, now that I got logged back on, I'm not able to see can't see if you're on your visual. So I'm just going to go down the list of the members and see if there's any questions. I'll start with our Vice Chair Schaefer.
Thank you, Chair Vasquez. I want to thank Mr. Dronenberg and all of the assessors for working so closely with our staff to try to get the right answers here. I notice on the proposed parent-child and grandchild exclusions, we define children as any child born of the parent or parents, except a child is defined in subparagraph D who has been adopted by another person or persons. And then you go to subparagraph D and it talks about anybody who is adopted other than an individual adopted after reaching 18 years of age. we're drawing a distinction between adopted children that are under 18 or over 18, or I guess what we're doing is we're zeroing in on the fact if you're going to be an adopted child, you've got to get your adoption in sometime between birth and 18 and not thereafter, like the theory that if somebody adopted somebody over 18, it might be just for purposes of favorable tax treatment. Is that really why we had that provision in there? Because the law of the state is that a child ends at 18, and we're only giving relief to child and grandchild here. So if that's the case, that's already in the law. We really don't need to start defining before or after age 18, do we? Does somebody speak to that?
Richard, maybe you might know the site. I think that's consistent with our current interpretation of the existing parent-child transfers.
That's correct. This is Richard Moon from the legal department. I believe that is correct. That it's what exists now in Section 63.1, and those definitions were carried over to 63.2.
I just want to know that we're protective whenever we can to people under 18, whether they're natural or adopted doesn't really make any difference, and we should be alert to that. Thank you.
Thank you. Member Gaines.
No further comment. Thank you.
Member Cohen.
Thank you. I have no further comments either.
Ms. Stowers.
No comments. Thank you.
Thank you. I have just a couple of quick questions, and my first one is to Mr. Dronenberg regarding the parent-child exclusion. There isn't anything in this proposal, I guess, as I look, section 63.2, about situations where a transferee or temporary vacates a principal residence. For example, if a transferee is called away for military duty or is in a convalescent hospital, what do you suggest, or do we need to maybe state that in some kind of a temporary LTA for some assistance there?
Well, I think putting it in an LTA never hurts. But because I think the principal, at least speaking from this office, thinking on how we're going to administer, we're going to rely heavily on the homeowner's exemption. And that's an annual thing. So if somebody leaves the house for 6 months because of a requirement that they be gone, it's not going to affect the homeowner's exemption. There's still the principal residence, and is, that of course is checked by the franchise tax board and the assessors checking the homeowner's exemption. So that would be my initial response to that question.
Thank you.
Chair Vasquez, this is Richard Moon from the legal department.
Thank you, Richard.
Sure, go ahead.
If I could chime in, you're correct, there is no definition or exception carved out specifically in 63.2 for those temporary type situations. And that's also the same for 63.1. And I think one of the reasons why there's no exception carved out specifically is because for the homeowner's exemption, there's an understanding that if you're away from your home temporarily, that's not by itself going to remove that home as your family residence. So, and I think those interpretations are imported in to our understanding of how the parent-child exclusion works. So, for example, if somebody were a member of the military and they were deployed overseas for 2 years, that would not cause them to lose by itself the homeowner's exemption on a home that they would have here.
Thank you. I understand Mr. Prang is back with us. So I have a couple of questions for him. The first one is actually it's in relationship to the base year value transfer for seniors and severely disabled. And the first one is the proposal authorizes the cancellation or refund of taxes on a replacement home to the extent that they exceed the amount due upon transfer of a new base year value to that home. So if someone, for example, let's say in Malibu sells their home for 4.8 million with a low base year value and purchases or rebuilds a $900,000 home in another part of the state or county, does that claimant get a refund? Is Mr. Prang on the line still?
I would think that you have to know the assessment base year value. And depending on what that base year value is and the time that the person is in the home. Could be a supplemental property tax issue too. Need more details in that question.
Okay. But at the end of the day, if somebody did do a transfer value on a piece of property that they sold that was worth more than what the new or the purchase of the relocation of a new home, for example, they would be entitled to some kind of a refund. Is that correct?
Now, I would have to go to my counsel, but we're not in the refund business. We can reduce their values, but we don't give taxes back unless we've incorrectly appraised them. That's just the basic tenet. If we, under the new rules, we made a adjustment in the value and it was more than what the property was worth, and they've already paid the taxes, then we would give them a refund.
Okay. So moving forward, it would get adjusted basically.
Yeah.
Okay. Yeah, somebody proposed this, and when they asked me the question, I wasn't sure. That's why I'm bringing it up. So, but that makes sense. I hear what you're saying. So at the end of the day, it doesn't really go retroactive, but rather moving forward when they move into their new home, if it's obviously at a lower value, they would be paying less taxes.
Yeah. Yeah. They have to pay some taxes that were erroneous before we'll give them a refund. And we're moving basis here. We're not moving taxes per se.
Okay.
This is Barbara Edgington. I'm wondering if I could just make a couple of comments in relation to that.
I can barely hear you.
Hard to hear. I said this is Barbara Edgington from San Luis Obispo, and I wondered if I just might make a couple of comments in relation to your question.
Sure, go ahead.
Thank you. I think that if I understood correctly, what we're looking at is regarding that refund that they refer to is if, for example, there is a transfer and the original home has a base year value of, let's say, $200,000, and if the replacement property has a base year value prior to the purchase of $400,000, then there might be a refund of some sort because there would be the reduction from the $400,000 down to the $200,000, but it's not a refund per se of the difference between the sale price of the 4.8 million down to whatever their purchase price is for the replacement. It's looking at the base year values between the original and the replacement.
Okay.
I'm sure that Mr. Moon could clarify that in better language, but I just wanted to make sure that there wasn't a misunderstanding about what that refund related to.
Maybe it's just terminology, but we don't give refunds. We adjust the basis. Somebody's got to have made them pay on the wrong amount. And we can adjust the basis, and we'll go back and reissue a bill at a lower amount. And it could cause the nothing in this new law creates a method that you could go. It's only a method that, if followed incorrectly, would create a overpayment of tax.
Hello, this is David Young, Deputy Director of the Property Tax Department. The only provision that if I may just comment, the only provision that I saw in Proposition 19 that talks about a refund is if you transfer your base year value to a replacement home and you do not, and it takes you within that first year to do so. You buy the replacement, it is reassessed at the time when you bought it, and let's just say the fair market value of the home is $600,000. Within the first year, you are able to transfer your base year value from your original home, and let's say that original base year is $200,000. Then if you've already paid the taxes on the $600,000 on your replacement, you are due a refund. And if you have not paid the taxes on it, but a bill has been generated, I believe there's a provision for the cancellation of that bill or a correction of that bill.
Yes,
I believe that's the only provision I've seen in Prop 19 that talks about a refund or a cancellation or change or correction of a bill.
That's a good point. So, for example, as a homeowner, you get your bill, and they allow you to either pay it all at once, or you could pay 2 installments, for example. So let's say you paid the first installment in April, and then you sell and you move into a home that's valued now at less in a different county, for example, or even within the same county, but has a lower base value. Then the second payment that would be due in December would be a lot less. Well, it would get adjusted. Yeah. And then, but you wouldn't be reimbursed for that first payment you made in April, would you?
It depends on whether it covers how much lower, I believe, the base year value is. If the first half installment covers the final corrected bill, then I think you are due or eligible for a refund. If it does not, then I believe there should be an adjustment to the second half. That would be the most logical application of that provision.
Well, that makes sense, yeah, because I'm thinking, especially if you're looking at something that in the millions, right, and you go down to something that's in the hundred thousands, you even if you paid only half of it, you probably have already overpaid.
Yes, that would be the most logical construction of that.
Okay, that makes sense.
Thank you.
That usually is part of a supplemental bill correction.
And then just my last question, I know under this new Prop 19, you're allowed to transfer your base year value up to 3 times. If one of those times is something that was done out of your control, for example, a wildfire, does that count against you as one of the 3?
This is David Young again. My understanding is that for disaster relief, the 3-time limitation does not apply to that, or it was not, at least not the intention of Prop 19, but it is for the provision that allows you to transfer it because you are age 55 or older, or because you're severely disabled. So the answer is, it does not count for disaster relief, but it does for what used to be called Prop 609110.
Okay. Thank you. With that, let me ask Ms. Taylor if there's any written comments or anybody on the line that wishes to speak on this item.
Yes, I have 7 written comments, and we do not have any public comments on the line yet.
Please go ahead.
Okay. Our first comment is from Joanne. I voted against Proposition 19 because of the provision that was slipped into the Home Protection for Seniors, Severely Disabled Families, and Victims of Wildfire or Natural Disasters Act regarding parent-child and grandparent-grandchild exclusion. This act constitutes legal theft against taxpayers without notice. The public was totally misled, and now you're in the process of legally clarifying the gray areas after the fact. That needs to be resolved in order to implement this proposition. However, you've given a hard date of February 16, 2021 for parents to transfer their properties to their children in order to obtain the exclusion before the law is finalized. Obviously, someone is in a hurry to take advantage of this license to steal. The assessor's office and BOE cannot answer any questions because implementing the statute is yet to be determined. The first part of this prop should have been a standalone proposition for voters to vote on. Most people still do not know how the second part of Prop 19 will affect their family's properties to their children, let alone giving a February 16th date to comply by. Corporations don't pay taxes, churches don't pay taxes, rich people don't pay taxes, yet you come after the taxpayers to steal their property one way or the other. I understand that the California Association of Realtors were responsible for this prop, backed by others, and more than $50 million to support this effort to get the prop passed that will directly financially benefit realtors. Shame on all of you. How do you expect anyone to trust what the government is up to when you pull these kinds of misdeeds? The information prepared for taxpayers to read the pros and cons of each of the bills prior to voting are very misleading. Find another way to take in revenue, but what's been proposed is theft. The next comment is from James Cunningham. Our law firm has met with more than 300 clients about Prop 19, and we are deeply concerned about the timing of the effective date of this proposition. In the last days, we have received in excess of 400 inquiries from the public about helping them with the repeal of Prop 58. Please consider delaying the effective date of Prop 19 with respect to the repeal of Prop 58. Many of our clients are low income, and when the home is reassessed, it will cause undue hardship on them. Many of our callers and clients have held the family home for 2 or more generations and make subsistence wages. If and when the family home is reassessed, it will cause extreme hardship for many. Elders are forced to gift their homes to children, and this is putting elders at risk. I encourage the board to adopt the broadest, most liberal interpretation of the family home exemption and not the proposed more restrictive approach. I read your notes and am concerned that the property may be reassessed if a child ceases to use the family home as a residence. This will be harming many, many people. Thank you. James L. Cunningham, Jr., Esquire, Certified Specialist, Estate Planning, Trust, and Probate Law. Good day, members of the board. Our firm represents taxpayers for assessment appeals and ownership issues. Often we have clients who have not filed a parent-to-child claim form, and their parents have been deceased for more than 10 years, and title is still in the name of the now irrevocable trust. Under law, they can still file the claim form, and no escape taxes should be issued. Under the future implementation of the law, if they do not move into the house, and if they do not file a homeowner's exemption claim within 1 year, upon discovery of the death of the surviving parent, the assessor is obligated to reassess. If this occurs in 2030, for example, and the parents died in 2023, the beneficiaries will be responsible for 8 years of escape taxes. Has this issue been addressed? Regards, Kent Miller, Assessment Counseling Services. This is a comment from Esther. It is impossible to say how laws that affect people with disabilities will change and how they will impact the estate we leave to our children with disabilities. We have decided against placing our home in a property protection trust because we need a solution that is fair to everyone with disabilities and not just those who have the knowledge and money to pay for this trust. It would give us great peace of mind to know that if the increase in property tax for our disabled children cannot be maintained at the base level that currently applies, that the increased property tax will be deferred until the person with disabilities dies with a lien for the unpaid amount placed upon the home. This would ensure that persons with disabilities do not lose the only home they've known because of increasing property taxes. Thank you for the hearing. This comment is from Will Becker. Question: if property has multiple uses, such as a primary residence, grazing, farming, and also a rental home, does it still count as a family farm? Or does the fact that it has rental income mean that it can't count as a family farm? Please address these Prop 19 issues. Proportionality. If a property is owned 50-50 by two people, and then one of them dies and transfers their half to their children, is only half of the property subject to Prop 19 reassessment, or is all of it reassessed? Primary residence. If the owner is in a long-term care home for health reasons, can their family farm still count as their primary residence? From Clyde Warren. Will all of the questions proposed today, the 14th, be answered and available to everyone? We are on a very tight timeline, so how soon are we going to get answers? Thank you. And the final written comment from Carolyn. Our family home is held in joint tenancy with myself, my husband, and our son. With this kind of ownership, as each person dies, it goes to the others equally and automatically. Does the Prop 13 exception from reassessment from parent to child pass on this way as long as this was before February 15th? Is the date of the transfer when the joint tenancy was established, or as each person passes away, it is reassessed? Those are the final written comments. I'll move on to the AT&T operator. AT&T moderator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter at this time?
Yes, for any public comment, you may press 10 at this time. And our first public comment will come from Scott Kaufman. Please go ahead, your line's open.
Hi, this is Scott Kaufman from the Howard Jarvis Taxpayers Association. We appreciate the cleanup language put forward by the assessors, but with such a tight deadline, the fact that the law needs 30-plus pages of fixes to be effectively administered says to us that taxpayers desperately need an extension on the implementation of at least the inheritance provision until this is all figured out. Had the assessors considered including such language, I know there are legislators interested in putting forward such a bill. Thank you.
Thank you. And our next public comment will come from Marianne Welsh. Your line is open.
Yes, I just would like to say, yes, the real estate people put out $63 million. However, the state legislature made a twist to it and put in, and they also donated $400,000, and they also are with the Democratic Party. And all of our legislators, both the Assembly and the state legislature, are all Democratic. So as far as I'm concerned, that's also a conflict of interest. But my main concern is this proposition is completely illegal because there's more than one. There's more than one issue on it. It's an issue of the fire people and the victims, and it's an issue of the inheritance people. That's two separate issues. What they tried to do is tie it in to taxation. However, it's two separate issues. And so, therefore, this is an illegal proposition that should be completely eliminated now. And you could see by all of the questions today that this is a big problem for middle-class people. This is a big problem for people with disabilities. This is a big problem for anybody with any property. It's what the other lady said at the beginning. This is a theft. This is stealing from people's only wealth. And most middle-class people, their only wealth is their home. And for the state to rip us off at this time with a virus going on, with the economy sort of in a tank right now,
is absolutely outrageous, to say the least. It needs to be completely repealed. It needs to be thrown out. It was wrong for the legislators to do it. It was totally corrupt, and they're only were looking for money. And no matter how much money we are taxed in this state, the legislators don't even use the money correctly anyway. There's never enough, never enough. I really believe that this is an improper proposition. It's illegal, and it should be eliminated now. Thank you.
Thank you.
Thank you. And as a reminder, it is 1-0 for any public comments. And we have no public comment in queue.
Thank you. Members, we're looking at 2 more presentations, and I understand those will be rather short. I was wondering what the will is of the members. Do we want to take a short break and continue?
Vice Chair Schaefer here. Are we done with the meeting, Chair Vasquez, if we have these additional 2 items?
I believe so. That's why I was asking if we can go through it, unless, maybe we may want to take just a short 5-10 minute restroom break.
Okay, I would move we have a 5-minute restroom break and then go on, and that means the meeting would end after we hear those 2 items. And then we can go to lunch.
That works for me. Let me see. Member Cohen?
Yeah, I'm in agreement with.
You're good with that? Okay.
Schaefer's proposal.
All right, so why don't we go ahead and just take like basically a little restroom break. You want to say 5, what's good, 10 minutes?
5 minutes isn't good.
Is 5 minutes good?
Yeah,
All
5
right.
minutes is good. We'll get back to it.
So I have 12:55. We say at 1 o'clock we'll reconvene. All righty, let's do that.
The collaboration with the California State Legislature, presented by Mr. Ernest Dronenberg and Ms. Brenda Fleming.
Chairman Vasquez and honorable members, thank you for the opportunity to add some further comment to this topic. Clearly, what we heard today was some urgency to move forward timely with legislation that offers some clarification and actually fills in the gaps of the Proposition 19. As you've heard from our taxpayers today who weighed in heavily, urgency is needed in order to support them and give them some relief. I won't restate what we heard earlier today, but I just want to emphasize for us that the draft legislation is a product, a collaborative document, and it's a product of a lot of people working together over the last, several weeks to put it together. What we would like to do, members, with your support, absolutely, is to move forward with a 2-prong approach. At this point, as you've heard from Mr. Grosslauser, the legislature is in a bit of an interesting time. They're moving forward quickly also with some budget bills at the direction and request of the governor. We have the opportunity, members, to either move forward with a committee bill or a sponsored bill. We also have the opportunity perhaps to look at it as an urgency bill, which potentially could be attached to the budget bill. That would be ideal if we could, because we'd like to move forward with a full comprehensive draft proposal. That material is attached to our PAN. But if for some reason moving timely in the form of an urgency bill, we're not able to move forward with the entire bill, at least initially, then a multiple phased approach would be appreciated. And that would be phase 1, moving forward with the provisions that need to be clarified for the February 16th date. And the second phase could be focusing on those provisions that are necessary for the April 1st date. So one of the things that we would be doing, obviously, with your support and engagement would be to work closely with the legislature to make sure that they're understanding the necessity, the importance, and the sensitivity of timing on this. In the interim, while we're deciding which is the best path forward as we're collaborating with the legislature, staff, the BOE staff, will immediately begin focusing on the guidance. And that would be our focus between now and the February 16th timeframe. As noted, members, it is very important. You've heard from your taxpayers today. Many of those taxpayers are also nested in the districts of the legislatures that are nested in your districts. So I think to the extent, members, that you are able to participate and provide your absolute leadership with the legislature to make sure they understand the importance of addressing this very significant taxpayer issue. And with that, I'm not sure, members, at this point, if Assessor Jonerberg is still on the line, but that would be our focus and my priority. Obviously, members will have more discussions tomorrow to get any additional direction from you in terms of approval of the legislative proposal for us to proceed with, and also with direction on guidance. Members, I'm available for questions if you have any.
Well, I'm here, and there's nothing I want to add other than to make sure that, you know, the majority of those questions all relate to the date, which is part of the initiative. You know, we have no discretion on these dates. And so, and any kind of amendment that we might want in the dual approach, we can put in the second bill where we've got more time. But if we want to get in the budget trailer bill, we've got to have a one-pager. That's been part of our instructions from the legislature, and that is the one that we really, really need as soon as possible. Thank you for allowing me to address you today, and thanks, Brenda.
Thank you for your participation, Ernie, much appreciated. So members, again, I think the focus for us is for all, is to ultimately have the full package of our legislative proposal, because it does address the comprehensive challenges with this legislation. But as is noted and discussed, we do have the challenge with the legislative cycle. So to the extent that we have some provisions right away in a smaller or a more abbreviated version of our proposal, referenced as the one page perhaps, where we can summarize that, but it primarily just focuses on provisions that are needed by the February 16th operative date. And then we would continue with the subsequent phases to ultimately get the full body of the proposal introduced. And again, we're available for any questions that you may have.
Thank you. Members, do we have any questions?
Thank you, members.
Seeing and hearing none, let me just ask one quick question. So, you know, based on what we just heard from Mr. Dronenberg, actually both Mr. Dronenberg and Ms. Fleming, I think we should consider doing, at least getting this letter out to the members, right? And I understand there's a, well, the CAA and the staff have already crafted this emergency legislation, I guess, that to try to address the issue of February 16th, the first deadline. And I'm wondering if it's probably the most appropriate use of our time right now is to at least get a letter in support of that from the board. What's the feeling from the members?
Chair Vasquez, what is it exactly you're asking for? You wanted to hear from us about a letter?
Well, you know what? As I'm reviewing this now and listening to what we've laid out so far, why don't we just hold and let's move on to the next. Well, first of all, let's see if there's anybody in the public that any written comments, or if we have any comments or anybody in the public to hear on this item. Because at the end of the day, I think we should just stick to what I had said originally at the outset in the beginning, just, you know, to put us back, I guess, on really listening mode, and then come back tomorrow with really the action items and motions that we all see fit after we have the opportunity to digest what we heard today, plus information and the discussion that we had among ourselves. Why don't we do that? Let me just get Ms. Taylor to check to see if there's anybody, if we have any written comments on this item, or to check with AT&T if there's anybody on the line on this specific item.
Oh. Thank you. There are no written comments for this item. AT&T moderator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter at this time?
Yes, any public comment, you may press 1, 0. And our first public comment will come from, one moment, 1, 0 for any public comment. Our next public comment will come from Mary Ann Welsh. Your line's open.
Yes, I would just like to thank the board for this because it's the only time the public has been able to talk about Proposition 19 because our legislators do not allow us any kind of information because they work for themselves and not for the people. I just like to say thank you for all of you, but I'd like to just make a couple of comments here. An increase of 600 to 700% on property tax is unjust, especially for hurting families at this time. The government forcing a sale or telling people what they can do with their property is not freedom of choice, but more like a socialist communist government. Also, Proposition 19 was written in a deceptive manner, prejudiced and unconstitutional, is a civil rights issue, has over 2 separate items, which is unlawful for sure for the voters to vote on, received no public hearing or review by the people of California before the vote, is a fraud to the voters, worse, unknown to the voters. The legislature underhandedly passed the 3 California constitutional amendments and Senate Bill 300 to put on the ballot the last minute, and Governor Newsom signed it. What I would hope this board could do more than anything else, because they're passing all of their issues over to the Board of Equalization, I would hope that the board doesn't send anything and just tries to put this legislation right now for the money they're trying to collect on hold. And I thank you again for having this meeting. I think it's very important, but I hope the board could just, instead of you guys doing the work of the legislators, I would hope that the board could just send them the legislators and tell them, let's put this on hold. There's too many issues and the public is very upset and people are hurting right now. And on top of it, the vote was, there was only 327,000 votes they got, which is a little bit over 51% of the voters out of 40 million people in the state of California. Thank you very much for this whole conversation. Thank you all. Bye.
Thank you.
Member Vasquez?
Yes, Member Gaines, go ahead.
Chair Vasquez, excuse me. Just to clarify on that issue, it's my understanding that we don't have the authority to slow this down. That dates are specific within the initiative itself. I'm wondering, could we get a comment on that from Mr. Moon or someone at the BOE? But don't we have to follow the initiative as it's written in terms of the timelines?
Member Gaines,
I would love to
Moon.
slow it down if we could, so we get more clarity, but I just don't think we have the authority.
This is Richard Moon with the legal department. You're correct. The operative dates are written into the constitutional amendment, the initiative itself. And so we would not have the authority. We do not have the authority to change those dates.
Okay. Well, I'm sympathetic to the concerns of the individual that had spoken, but I just wanted to clarify that so that she is aware of what our parameters are as members of the BOE. Thank you.
Good point. Thank you. Anybody else, Ms. Taylor?
I believe there's still someone on the AT&T line.
Okay.
Yes, our next public comment comes from Peter Kaiser. Go ahead.
Individual that had spoken, but I just wanted to clarify that.
Peter Kaiser, your line is open.
Yes, I'm ready. Do I start speaking?
Sure, go ahead. But you may want to turn down your audio because it sounds like you're getting some backfeed there.
Hi, yes. My name is Peter Kaiser, and I'd like to speak to this. We should have a remedy in the legislature on the on this. Your line is open. Yes, can you hear me?
Yes, we can hear you.
I'm Peter Country West. Okay, so yes, I'm very concerned about the parent-child for the other property other than the primary residence. It looks like what could happen here is that most of the families, hardworking middle-class families with these maybe an additional property, may lose that during the time of the reassessment and be paying several hundred more percent, and they may have to just sell those. So we will ask the Board of Equalization to please, in this single-page letter or the longer legislation, to seek a remedy for that, for these families won't be losing all their second properties, and that they will be able to keep them and not be having all these real estate sales that would may be an advantage to some other associations in the state. So please include that in the one page or in the larger legislation to make a remedy for this so that they can use the previous base value and not be reassessed and maybe lose all those properties that they worked hard to buy and to save and want to pass on to their children. Thank you so much for this hearing and your time on this, and bless you.
Thank you. Ms. Taylor, is there anybody
We
else?
have no further public comments. Thank you.
Okay, with that, members, Ms. Taylor, if you would go on to the next item.
Yes. The next sub-item is M1A2, the Proposition 19 and Implementation Planning Matrix presented by Mr. Young.
Good afternoon, all. Good afternoon, Chair Vasquez and honorable members of the board. This is David Young, Deputy Director of the Property Tax Department. What I have before you today is a presentation on the Prop 19 matrix analysis. As you may recall, I presented this item in December at our December board meeting. At that time, the matrix contained the board staff's analysis of Proposition 19, what each provision did, our concerns with those provisions, and our options in addressing those. At the same meeting in December, CAA, the assessors, also presented their list of concerns and issues. A request was made that we go ahead and update the matrix and incorporate the assessors' concerns and issues into it, and that is indeed what is before you. It is now it is a compilation of both the board's and the assessors' issues and concerns. It is 45 pages long, so what I will do is just give you a very brief update on it. The right-hand side most column, the concurrences, are what I will focus on. If you look at the setup of the actual matrix, the provisions are in the second column. What it does is in the third column. The board's concern, as before, is in the fourth column. CAA's concerns and issues are in the fifth column, followed by the board's options and its CAA options. Where we have concurrences, I've drawn particular note. So the options typically fall into three categories: legislation, rulemaking, and guidance. And so we've identified actually two items that will require basically constitutional amendments. And Mr. Moon has already touched on them earlier today. I will just go revisit them very briefly. One is under Prop 19, there is a 2-year time limit for a base year transfer. Currently, For disaster relief, it is currently a 3-year for inter-county, and within the same county, it's 5 years. As Mr. Moon so correctly articulated, a 2-year may be a little bit short, and if there is a desire to change that, that would require a constitutional amendment. And the same is true for retroactive or prospective relief. If something happened prior and they did not get benefit under the old statutes, for them to get benefit under a new statute will require a constitutional amendment, because they are hard dates put into Prop 19. We've also identified at least 5 areas that would require legislative remedies, and those concerns were incorporated into the legislative proposals. And so, along with this matrix, Mr. Moon's, Chief Counsel's memo, all of the concerns and issues raised in there were incorporated and were presented earlier today with the legislative proposal. So I am confident we got what was identified. What remains to be seen is what has not been identified. I'm sure there may be other issues that will come up, but we did our best in identifying and addressing those issues. And the last option that we have is guidance. We have noted that there were several areas that would probably be addressed in guidance. Let me go through some of them right here. For the parent-child, guidance as to what would qualify as a family farm and a family home, how to handle mixed-use properties, and guidance on appeal rights. In particular, with the parent-child, grandparent-grandchild transfers, what happens with if somebody is actually, the transferee is denied the homeowner's exclusion or the disabled vet's exclusion, exemption, what are their appeal rights? And Mr. Moon covered part of that this morning already. For base year transfers, some of the guidance that was sought and that we could cover would be how to calculate values to be transferred, and that is both for the seniors and the severely disabled, and for base year transfers due to disaster, and also guidance on how many times may a spouse transfer their base year value to. And we already have some opinion. We have an opinion that each one can do it 3 times. Staff has already begun the review of our published guidance in our various LTAs, assessors handbooks, and annotated letters. And as we identify them and develop answers, we will be issuing new guidance. And in particular, we will be paying a very, very close attention to the legislative process too. Some of the guidance will depend on that. So that is my presentation. I hope I have summarized it enough for you so that you do not have to digest all 45 pages. Thank you. I am available for any questions you may have.
Thank you, Mr. Young. No, I think you did a good job. And like you mentioned, actually, a couple of my questions were actually already answered earlier in your presentation. But let me open it up to the members and see if there's any other questions. And since I can't see you on the screen, I'm just going to start with our vice chair and then go down the list. Vice Chair Schaefer.
I have no further questions, Chair Vasquez. Thank you.
Member Gain.
No further questions. Thank you.
Member Cohen.
No further questions.
Controller, actually our Deputy Controller, Ms. Stowers.
No questions at this time, thank you.
Thank you. Let me ask Ms. Taylor if there's any written comments on this item.
Yes, we have 2 written comments.
Okay.
The first is from Eric St. George. First, I want to thank you for your hard work in trying to clarify Prop 19 as quickly as possible. May I suggest to include in the Proposition 19 and Implementation Planning Matrix the request for clarification of the following. Do additional construction improvements to a newly acquired home meeting the Prop 19 requirements remain under the Prop 19 umbrella as long as the total value of the acquisition plus the new construction remains below the value of the sold property, and as long as the work is done within the 2-year window? Thank you very much. Best regards, Eric St. George. Our second comment is from Albert Batate. I am concerned about Prop 19. There have been succession planning going on for generations to save our farms, ranches, agricultural lands have risen in value to the point where people can't afford to purchase them and support themselves because the cost of raising livestock or crops can't support the cost of the land. My point is that most ranches and farms have been passed down generation after generation. Prop 19 will gravely affect the ability to pass these farms and ranches to our children and grandchildren. I'm afraid Prop 19 is the beginning of the end to sustainable agriculture in the state of California. That completes the written comments.
Ms. Taylor, can we check with AT&T?
Certainly. AT&T moderator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter at this time?
Yes, thank you. If you'd like to have public comment, you may press 10 at this time. And our first public comment, oh, she disappeared, 10. Our first public comment comes from Mary Ann Welsh. Please go ahead.
Yes, I would just like to ask the board one more question. At this present time, what can the citizen actually do now? Because apparently the legislator doesn't really listen to us or talk to us. So what can the citizen do right now to get the legislators to hear the citizens of California?
Thank you. And we have no further public comment.
Okay, with that, Ms. Taylor, we can go on. I believe this is our last item of the day.
Correct.
Chair Vasquez, Vice Chair Schaefer.
Vice Chair Schaefer, go ahead.
Of the public comments, some of them didn't really require any response, like how do we get the legislators to listen to the people or whatnot. But the first one was asking a question of us, the first public comment. I assume that staff would send some appropriate administrative response to them rather than any one of us.
That is correct.
Right. Thank you.
Thank you. Ms. Taylor.
The last sub-item is M1A5, the implementation of forms and processes presented by Ms. Lumsden.
Good afternoon, Chair Vasquez, honorable board members, and Deputy Controller Stowers. This is Patty Lumsden. I'm the Chief of the County Assessed Properties Division at the State Board of Equalization. Today, I'm here to discuss the forms portion of the Proposition 19 implementation plan, which is a necessary and important component of the plan. Government Code Section 15606 requires that the board prescribe and enforce the use of all forms for the assessment of property taxation, including forms to be used for the application for reduction in assessment. This helps to ensure uniformity of property tax administration throughout the 58 California County Assessors offices, ensures that the forms conform with California statutes and regulations, and that the forms are not unnecessarily difficult for taxpayers or claimants to complete. Pursuant to this mandated duty, BOE staff have identified and created 7 new forms and amended 5 existing forms. These forms are currently going through an in-house review process. The purpose of these amendments and creations will be to help assessors collect necessary information to determine whether a claimant or taxpayer is eligible for the base year value transfer exclusion. Also to help assessors collect data from other assessors regarding transfers, base year value transfers that occur from one county to another county, and also to assist in collecting necessary data that may be required due to constitutional amendment of sections 2.2 and 2.3. So once we have completed our review of these 12 forms, we will be sharing the forms with the California Assessors Association's Forms Subcommittee and also their Proposition 19 Implementation Ad Hoc Committee for their review and further input to ensure that these forms will meet the needs of the assessors and their staff when collecting this necessary information and data as part of implementing Proposition 19. Once these final versions of the forms have been completed, as part of our typical procedure when there is a need to expedite a form, we will then issue these forms by way of a letter to assessors as quickly as possible in order to meet the first operative date of February 16th, 2021. These forms will then be posted to the BOE's assessor portal for assessors and their staff to have access to immediately. This will give the assessors time to incorporate the new and amended forms into their own systems, placing their office logos and tracking information on the forms. After the letter to assessor has been issued, then the next step would be to conclude all 12 forms in our regular annual forms approval process, which will start in February of 2021 this year. Those 12 forms will then go through the approval process of the CAA's Form Subcommittee, where members of the committee can provide any additional changes or input they deem necessary. Any further changes to these forms would be in collaboration with BOE staff and the members of the committee. Once approved through the Form Subcommittee process, these 12 forms, along with all other forms created and amended, approved by the committee for the January 1, 2022 lien date, will be presented to the board members for their final approval and adoption at the board meeting in May 2021. That concludes my presentation, and I'm available to answer any questions you may have regarding the forms process.
Thank you. Members, do we have any questions for Ms. Lumsden? Let me start with our Vice Chair Schaefer.
Vice Chair here, I have no further questions. Thank you.
Member Gaines.
No, thank you. I'm fine.
Member Cohen. Deputy Controller.
Sorry, I'm fine.
You're good? Okay.
Thank you for the report. No further questions at this time.
Thank you. The only question, well, let's check and see if there's any, do we have any written comments on this, Ms. Taylor, from the public?
Chairman, we do not have any written comments on this item.
Can we check with the AT&T?
Certainly. AT&T moderator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter at this time?
Thank you. And any public comments, you may press 10 at this time. 10 for any public comment. And one moment while we gather their name. One moment, please. And public comment will come from Di Root. Please go ahead.
Hi, this is Dia Rudd, and my question is, will these forms be uniform throughout the state, or are they going to be per county?
Yes, so in answer to your question, so that is the purpose of the board issuing these forms, is so that they will be uniform throughout the state and not just different counties having different things. The only thing that will be different is each county will have its own individual logos and tracking information put on those forms.
So my further question is then the question about that Ms. Eddington brought up about the difference in different counties may have family farms listed under units, and some may have them listed under parcels. So there was some gray area as how that would be handled throughout the state. Will that be clarified with these forms, or will that still have to be clarified per county?
This might be something that Richard Moon can add to, but I just want to say that the forms themselves will collect the information as needed, and that the clarification will have to come through either further legislation or guidance in regards to the appraisal unit versus parcel numbers.
All right, thank you, and thank you for the forum today.
Sure, you're welcome.
Thank you. Any others?
No further public comment in queue.
Thank you, Ms. Taylor. With that, members, we will conclude this portion of the meeting and reconvene tomorrow. But I wanted to, and before we close out, especially for the public and all the questions, we had some very good questions raised throughout the day today. And it's my understanding that we may not have everybody's information accurately to get back to everybody. So if for some reason you are not contacted by one of our staff persons to follow up on your questions, please feel free to log into our website. It's my understanding that that's being updated as we speak, and it's going to have many of those questions that were raised answered on our website. And also, if for some reason your question isn't answered on our website, by all means, feel free to reach out to our BOE Property Tax Department directly. And their phone number is area code 916-274-3350. Once again, that's area code 916-274-3350. Or you could email at ptwebrequest with an S at boe.ca.gov. And once again, I want to thank all the participants and especially the public. I think you've raised some real good questions. And as was mentioned earlier by one of our members, that to a certain extent, our hands are tied with, especially with these deadlines that are coming up, specifically the one in February and the other one in April. But we will do our best, hopefully tomorrow, to come up with a game plan, an action plan, and some motions, and hopefully letters of support as well, to address some of these issues and to do as much as we can within the law and within this new Proposition 19 that was just passed. With that, I would like to officially close this part of the meeting, and we will reconvene tomorrow at 10 a.m. Unless there's any other comments or questions from the members, we stand in recess.
Vice Chair Schaefer.
Vice Chair Schaefer, yes, go ahead.
Well, I always find some other significant item on the day when we close our meeting. Today's the 53rd birthday of LL Cool J, who I got to know in Las Vegas, Nevada, one of the more colorful people in our entertainment world. He's 53 today. We can say happy birthday to him. Thank you.
Thank you. With that, members, we will go ahead. Like I said, it's not an official adjournment, but rather a recess, and we'll reconvene tomorrow morning at 10 a.m. Once again, thank you all. And please, members, take an opportunity this evening to go back, and I know you've all taken copious notes, to just refresh your memory so when we come back and reconvene tomorrow, we can take some action. Thank you once again.